Annexure J, now they want to fill up my place, my lord. They called for appointment of in my place. On 92.
ಪಂಚಾಯತ್ ಯೋಜನೆಯಡಿ ಹೊರಗುತ್ತಿಗೆ ಆಧಾರದ ಮೇಲೆ ಜಿಲ್ಲೆಗೆ ಜಿಲ್ಲಾ ಯೋಜನಾ ವ್ಯವಸ್ಥಾಪಕ ಹುದ್ದೆಗೆ ಹೊರಗುತ್ತಿಗೆ ಮಾನವ ಸಂಪನ್ಮೂಲ ಸಂಸ್ಥೆಯ ಮೂಲಕ ಹೊರಗುತ್ತಿಗೆ ಆಧಾರದ ಮೇಲೆ ನೇಮಕಾತಿ ಮಾಡಿಕೊಳ್ಳಲು ಆನ್ಲೈನ್ ಮೂಲಕ ಅರ್ಜಿಯನ್ನು ಆಹ್ವಾನಿಸಿದೆ.
ಕೊನೆಯ ದಿನಾಂಕ 13/22 ಫೈಲಿಂಗ್ ಆಫ್ ಅಪ್ಲಿಕೇಶನ್. Now they are removed on 17/2/2022.
There is no direct appointment made by the first respondent.
2015 to
yes.
Today I am working.
Correct. It is only through the third respondent.
Through the agency.
It's a contract.
But contract, my lord, as per Annexure C, that first respondent they cannot remove me without issuing a notice, my lord. Because during
first respondent ilri barutte. You were never appointed by the first respondent.
Yes, we first through the Annexure A.
It is a appointment through an agency. The first respondent never appointed you.
They have taken, my lord. As per publication Annexure A. ಪಂಚಾಯತ್ ರಾಜ್ ಇಲಾಖೆ ಈ ಪಂಚಾಯತ್ ಕಾರ್ಯಕ್ರಮಗಳ ಅನುಷ್ಠಾನ ಬಗ್ಗೆ ಜಿಲ್ಲಾ ಯೋಜನೆ ವ್ಯವಸ್ಥೆ ನಿರ್ವಹಿಸಬೇಕಾದ ಕರ್ತವ್ಯಗಳ ಬಗ್ಗೆ ಇದು. Annexure B
Annexure B is given by the third respondent, not by the first respondent.
Then you to report, you shall report to the undersigned at the office of Jilla Panchayat of the district.
Correct, sir. You are working through the agency.
My lord, they have no right to remove.
There is no privity of contract between the first respondent and you directly.
Yes.
Then,
but I'm working up to 2000.
Sir, it is only a contract.
Up to 17.
Yes. Recently, I have dismissed a similar petition on the same ground.
Because I have gone for a treatment, medical treatment for conceiving a pregnancy, my lord. As per Annexure C, my lord, I might kindly see the Annexure C, my lord.
Sir, there is no privity of contract. There is no direct appointment.
Through the agency.
Mate? Barkale.
Give me 2 days, I will verify and
verify alla neeve file ಮಾಡಿದಿರಲ್ಲ Annexure B.
Yes, my lord.
ಮತ್ತೆ
I will verify.
ಏನು verify ಮಾಡ್ತೀರಾ?
ಹೇಗೆ ಅದು?
ಇಲ್ಲ ಬರೋದಿಲ್ಲ.
ಅಲ್ಲ ನೋಡ್ತೀನಿ.
No, because I have dismissed similar petition. Yes.
3 days, my lord.
No,
request.
No, sir. No, sir.
Monday. Trace out any chances are there. Notice, verify.
You have not prepared any ground. ನೀವು ಹೊಸದಾಗಿ ಏನೋ ಒಂದು ನೋಡ್ಬಿಟ್ಟು ಮತ್ತೆ ಹೇಳ್ತೀನಿ ಅಂತಂದ್ರೆ ವೇರ್ ಇಸ್ ದಿ ಗ್ರೌಂಡ್?
What basis? Because of agency, my lord.
That is very clear. That is how it is done.
Research 2-3 days, my lord. I'll verify.
No.
If it is possible, then
see, on facts, I don't think there can be any dispute.
Yes, my lord.
ಮತ್ತೆ ಏನ್ ಮಾಡ್ತೀರಾ?
ಯಾವ ತರ ಇದಾಗಿದೆ verify.
ನೀವೇ ಕೊಟ್ಟಿದಿರಲ್ಲ ಸಾಹೇಬ್ರೆ Annexure B.
Discuss with the party then Monday or Tuesday next week.
Although this court noticed that under similar circumstances, another petition in WP number so and so was dismissed on noticing that there was never privity of contract between the petitioner and the Zilla Panchayat. And therefore, the petitioner cannot claim that he or she was employed by the Zilla Panchayat, and consequently, they could not have removed the petitioner from service. Was negative. and the writ petition was dismissed, however, at the request of learned counsel for petitioner, released this matter on 28th of March.
Petitioner, my lord, is working as superintendent in Karnataka State Open University. Challenging the order of suspension relating to an alleged incident of year 2015. Suspension order is passed in 2022. Relating to an alleged incident of year 2015. What happened, my lords? The TC, my lords, had not granted approval for courses which were run by the Karnataka State Open University. Therefore, my lords, KSOU took a decision and intimated this decision
The
that
Karnataka Education Act is not applicable to you.
they have adopted Mysore University employees sees classification controls and appeal statutes. The suspension order is passed under that. That I have produced, my lords, at page 97 of statutes. The suspension order, they refer to statute class 7 of this statute.
So,
My lords, the points, my lords. The incident relates to year 2015.
what is the jurisdiction and scope of the Karnataka Education Act for redressing grievance of teachers and non-teaching staff of an education institution? Why do you say that you don't come under the purview of the Education Act?
I look into my lords is pointing out that I have an alternative remedial
Yes.
for Karnataka Education. I look into it. Your lordship may kindly take this on Monday.
At the request of learned counsel for petitioner, released this matter on 28th of March.
We have to list the cadre of not the additional chief engineer is under challenge. But, in the my lords have heard one matter, my lord, in the lower cadre pertaining to my lord executive engineer, but I cannot withhold that information. But, in the present petition,
Sorry, bari notice issue madare saka?
yeah, for consideration of interim prayer and that, but in the lower cadre, my lords have not fixed it, not adjourned the matter to 29/3/2022. Not in petition number 449 of 2022. But, if I am permitted to make my submission in this matter, I will make. But, however, but without referring, not I cannot withhold that information.
Adikena, that is why we will list it along with those matters.
Preliminary hearing ಗೆ ಬರ್ಲಿ.
No, not connecting. Not connecting. We will list it on the same day.
ಏನಕ್ಕೆ ಅಂತ ನಂಗೆ ಗೊತ್ತಿರೋ ವಿಷಯ ಸುಮ್ಮನೆ ಹೇಳಿದ್ದೇನೆ.
ಯಾರು BL ಸಂಜೀವ್ ಅವರ ಪೇರ್ ಆಗ್ತದಾರ ಅದರಲ್ಲಿ?
ಹೌದು ಸರ್.
Learned counsel Shri BL Sanjeev, the directive to take notice for response number 1. Issue emergent notice to response number 2 and 3. The petitioner is also permitted to take out hand summons to response number 2 and 3.
Private respondent, not AV Nishant has appeared in those matters.
ಅಲ್ಲ ನೀವು ಅವರು ಕೊಡಿ ಪ್ರೈವೇಟ್ ಪಾರ್ಟಿಗಾದ್ರೆ ನಾವು ವಿ ಕಾಂಟ್ ಸೇಲ್ ಲೈಕ್ ದಟ್. ಇವು ಅವರು ತಗೊಳಂಗಿದ್ರೆ ಕೊಡಿ. Learned counsel for the petitioner is directed to serve 2 sets of copies of the petition along with annexures on learned counsel for respondent number 1. Release this matter on 29th of March.
For consideration.
For consideration of interim.
I appear for the petitioner. The petitioner retired from service as assistant executive engineer, KPTCL. Retirement benefits have not been paid on the ground that they may institute the department proceedings. Only provisional pension has been fixed. There is no interim matters for the time being. Last matter notice.
ಯಾರ ಪೇರ್ ಆಗ್ತಾರೆ ಈ KPTCL ಮತ್ತೆ ಇದಿದೆ ಸೆಸ್ಕಾಮ್ ಚಾಮುಂಡೇಶ್ವರಿ HV ದೇವರಾಜ್ ಅವರು ಇದಕ್ಕೆ ಅಪೇರ್ ಆಗ್ತಾರಲ್ವಾ KPTCL ಗೆ ಶ್ರೀ HV ದೇವರಾಜ್ counsel is directed to take notice for all the respondents. Learned counsel for the petitioner is directed to serve 2 sets of copies of the petition along with annexures on the learned counsel for the respondents.
Bless.
Held up in other court.
Pass over.
Petitioner waived 12 lakhs for housing loan in 2016 and respondent number 4 and 5 stood as a guarantee for non-payment of balance amounts. Dispute was filed by the third respondent and she appeared and she has asked time, but later she has lost job and not paid the amount. Now they have issued Form 8 and 9 to auction her mortgaged property. To pay 25%.
ಆಮೇಲೆ
ಮತ್ತೆ ಸೆಟ್ಲ್ ಮಾಡ್ತಾರೆ, ರೆಗ್ಯುಲರೈಸ್ ಮಾಡ್ತಾರೆ ಅವರು ಒಮ್ಮೆ ಕೊಟ್ಟರೆ ಅಮೌಂಟ್.
What is the award amount?
What amount? 14,10,176.
Plus ಬಡ್ಡಿ ಮುಂದಿನ ಬಡ್ಡಿನಾ
14 ಲಕ್ಷ ಅಸಲು ಬಾಕಿ 12% ಬಡ್ಡಿ ಮತ್ತು ಸಂಘದ ನಿಯಮಾನುಸಾರ ದಂಡನ ಪಾವತಿ ಬದ್ಧರಾಗಿರುತ್ತಾರೆ. Form 8 and 9 also issued for same amount.
ಹೌದ್ರಿ, ಬಟ್ ಯು ಡೋಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಕಾಪಿ ಆಫ್ ದಿ ಅವಾರ್ಡ್, ಇಸ್ ಇಟ್?
What a producer.
ಎಲ್ಲಿದೆ?
Annexure C. Page number 14. Davarjan
ವಾಟ್ ಇಸ್ ದಿ ಅವಾರ್ಡ್ ಅಮೌಂಟ್? ಅದಕ್ಕೆ ಕೇಳಿದ್ ನಾನು.
14,10,176. ಬಾಕಿ 12 ಲಕ್ಷದ ಮೇಲೆ ದಿನಾಂಕ 1/2/2018 ಪಾವತಿ ದಿನಾಂಕ 12 ದರದಲ್ಲಿ ಬಡ್ಡಿ ಹಾಗೂ ಸಂಘದ ನಿಯಮಾನುಸಾರ ದಂಡನ ಪಾವತಿ ಬದ್ಧರಾಗಿರುತ್ತಾರೆ.
Learned AGA takes notice for response number 1 and 2. Issue notice to response number 3 to 5. Learned counsel for the petitioner is directed to serve a copy of the petition along with annexures on the learned AGA. Next para. There shall be an ad interim order of stay of all further proceedings pursuant to auction notice dated 9/2/2022. At annexures A and B, till the next date of hearing, subject to the petitioner depositing 25% of the award amount with the third respondent cooperative society, within a period of 4 weeks from today, failing which the benefit granted to the petitioner under this order shall stand cancelled automatically. Read this matter on 22nd of April.
Last station we got 2 weeks time.
ಏನ್ರಿ ಆರ್ಡರ್ ಶೀಟ್ ತುಂಬಾ ಎಲ್ಲ ಬರೀ ನಿಮ್ ರಿಕ್ವೆಸ್ಟ್ ಇದೆ.
ಟು ವೀಕ್ಸ್ ಟೈಮ್ ಶಿವಮೊಗ್ಗದಲ್ಲಿ
ನೋ ಸರ್, ನೋಡಿದ್ರೇನ್ರಿ ಇದು HCGP? ಗೌರ್ಮೆಂಟ್ ಇಲ್ಲ. ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆನ್ ಕಂಪ್ಯಾಷನೇಟ್ ಗ್ರೌಂಡ್ಸ್. ಮತ್ತೆ ಯಾಕೆ ನೋಟಿಸ್ ಯಾಕೆ ಆರ್ಡರ್ ಮಾಡಿಸ್ಕೊಳ್ಳಿಲ್ಲ ಇಷ್ಟು ದಿವಸ?
ಸೀನಿಯರ್ ಆಫೀಸರ್ ಇದ್ದಾರೆ, ಅದಕ್ಕೋಸ್ಕರ ಟೈಮ್ ಕೇಳಿ ಅಂತ ಹೇಳಿದ್ರು. 2 weeks ನೆಕ್ಸ್ಟ್ ವೀಕ್.
ಅದೇ ಹಿಂಗ್ ಮಾಡಿ ಸುಮ್ನೆ ಕೇಸು ಇರೋದಷ್ಟೇ. ನೀವು ಫೈಲ್ ಕೊಟ್ರೆ ಓದ್ಬೇಕು, ಏನು ಇಲ್ಲ ನಿಮ್ಗೆ. ನೀವು ನಿಮ್ ಸೀನಿಯರ್ ಸರಿಯಾಗಿದ್ದಾರೆ, ನೀವು ಸರಿಯಾಗಿದ್ದೀರಾ. ಕಂಪ್ಯಾಷನೇಟ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ಗೆ ಅರ್ಜಿ ಹಾಕಿದೀರಾ, ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. ಆನ್ ಡೈರೆಕ್ಷನ್ ಕೊಡಿ ಅಂತ ನಿಮ್ಮ ಇದು ಪ್ರೇಯರ್ ಇರೋದು. ನೋಟಿಸ್ ಆದ್ರೂ ಇಶ್ಯೂ ಮಾಡಿಸ್ಕೊಳ್ಳೋದು ಬೇಡವಾ? ಅದನ್ನೇ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳ್ಬೇಡಿ ದಯವಿಟ್ಟು. ಫೈಲ್ ಕೊಟ್ಮೇಲೆ ಫೈಲ್ ನೋಡ್ಕೊಂಡು ಬರ್ಬೇಕು, ಗೊತ್ತಾಯ್ತಾ? ಹೈಕೋರ್ಟ್ ಮುಂದೆ ಇದ್ದೀರಾ ನೀವು, ಜ್ಞಾಪಕ ಇರ್ಲಿ. ಇನ್ನೊಂದ್ಸರಿ ಫೈಲ್ ಕೊಟ್ರೆ ಫೈಲ್ ಏನು ಅಂತ ಸ್ವಲ್ಪ ತೆಗೆದು ನೋಡ್ಕೊಂಡು ಬರ್ಬೇಕು. issue notice to the respondent.
Challenging the seniority issue by respondent as per section A. Prior to that, the seniority list has been issued and as per annexure B 5/5/2018. Petitioner's name was been included in serial number 126, page 65. Dinesh
2020. KPTC Learned Counsel Shri Ajit Shetty is directed to take notice for respondent. Learned Counsel for the petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on the Learned Counsel for the respondent. GS. Matters called out. There is no representation for the petitioner. Release this matter on 31st of March 2022. If there is no representation for the petitioner on the next date of hearing, this writ petition will be dismissed for non-prosecution. ಏನಕ್ಕೆ the counsel for the petitioner submits that seeks for a short accommodation to file a memo at the instance of the petitioner to withdraw the writ petition. Full stop. Therefore, release this matter on 31st of March. Yes.
It's a request to the government to implement this as a special case. Once we go by the contention of the respondents, I have made applications within the time, and they have given an endorsement that you may apply after the majority of this.
So after this writ petition is filed, they have issued the endorsement
Yes.
rejecting your.
Rejecting my claim for implementation of TG and IG.
Then if you are aggrieved, then you have to file a fresh petition. Not in this petition. Because you will have to make out grounds. For some reason, they have rejected your application. So you will have to make out grounds for that one, isn't it? That cannot be incorporated in the present writ petition. We will permit you to file a fresh petition in view of the subsequent developments. Berkeley. Although learned counsel seeks to file an interlocutory application challenging the fresh endorsement dated 27/1/2022 issued by the DG and IG na by the second respondent, state government, Department of Home, rejecting the application filed by the petitioner seeking appointment, this court is of the considered view that since the application of the petitioner has been rejected subsequent to the filing of this writ petition, and if the petitioner is aggrieved of such endorsement, he will have to file a fresh petition challenging the endorsement. Stop. Next para. Consequently, the writ petition stands dismissed, granting liberty to the petitioner to file a fresh petition challenging the endorsement dated 27/1/2022 issued by the respondent state government, ordered accordingly.
Is challenging annexure in and over. Respondent number 4 is appointed. Yes. Of the third respondent. The recommendation was earlier forwarded, and Jilla Panchayat has returned with the objection that it is not as per law. Check is the endorsement given by the Panchayat. Recommendation is available at page 1 annexure G, page 38.
ಓದಿ.
ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ವೃತ್ತಿಗೆ ಗ್ರಾಮ ಪಂಚಾಯತ್ನಲ್ಲಿ ಉಲ್ಲೇಖ 1ರಂತೆ ಸ್ವಚ್ಛತಾಗಾರ ಮತ್ತು ಜವಾನ ಹುದ್ದೆಗೆ ಪೂರ್ವ ನೋಂದಣಿಗೊಂಡಿರುತ್ತದೆ. ಅದರಂತೆ ಶ್ರೀಮತಿ ಸುಚಿತ್ರಾ ಪಿಜಿ ಅವಕಾಶ ಇವರನ್ನು ಸ್ವಚ್ಛತಾಗಾರ ಹುದ್ದೆಗೆ ಮತ್ತು ಶ್ರೀಮತಿ ಸ್ಮೃತಿ ಸುರೇಶ್ ಇವರನ್ನು ಜವಾನ ಹುದ್ದೆಯ ನೇಮಕಾತಿಗೆ ಅನುಮೋದನೆ ನೀಡುವ ಉಲ್ಲೇಖ 2ರಂತೆ ಪಂಚಾಯತ್ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಇವರು ಈ ಕಚೇರಿ ಮುಖಾಂತರ ಸಲ್ಲಿಸಿರುವ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಈ ಪ್ರತಿಯೊಂದಿಗೆ ಲಗತ್ತಿಸಿ ಮುಂದಿನ ಕ್ರಮಕ್ಕಾಗಿ ಅವಗಣನೆಗೆ ಸಲ್ಲಿಸಿ.
2017.
Please. This has been returned. Annexure K, page 42.
ಅದಾಯ್ತು. ಅದಾದ್ಮೇಲೆ ಒಂದು ರಿಟ್ ಪಿಟಿಷನ್ ಫೈಲ್ ಆಗಿದೆ.
Rit petition ಅಲ್ಲಿ there was only observation to forward the document. ಕೆಲಸ ಕೊಡಿ ಅಂತ there is no direction.
Page 46. This is the understanding between the panchayat and the petition.
Petitioner has been appointed as peon on compassionate ground, but the proposal has not been sent to the Zilla Panchayat. Therefore, petitioner has filed his petition seeking direction. Petitioner has not been appointed. However, as resumed shown passed.
The competent authority has to
Proposal should
independently
not be
consider.
sent.
Actually, N may kindly visit. I could direct ಮಾಡಿದಂತೆ appoint. Actually, N may kindly
Where is
visit.
the previous? ಅದೇನೋ ಹೇಳಿದ್ರಲ್ಲ ರಿಜೆಕ್ಟ್
Annexure K page 42. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ
ತಾಲೂಕು ಕೊಟ್ಟಿಗೆ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಸಿಬ್ಬಂದಿ ನೇಮಕಾತಿ ಅನುಮೋದನೆ ನೀಡುವ ಕುರಿತು ಪ್ರಸ್ತಾವನೆಯನ್ನು ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿಯವರ ಮುಖಾಂತರ ಈ ಕಚೇರಿಗೆ ಉಲ್ಲೇಖ ಪತ್ರದಲ್ಲಿ ಸಲ್ಲಿಸಿರುತ್ತೀರಿ. ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿದೆ. ನೇಮಕಾತಿ ಪ್ರಕ್ರಿಯೆಯು ನಿಯಮ ಬಾಹಿರವಾಗಿ ನಡೆದಿರುವುದರಿಂದ ಈಗಾಗಲೇ ಮಾಡಲಾಗಿರುವ ನೇಮಕಾತಿಯನ್ನು ಅಧಿಸೂಚನೆ ಹೊರತುಪಡಿಸಿ ನಿಯಮಾನುಸಾರ ಹೊಸದಾಗಿ ಪ್ರಕ್ರಿಯೆ ಪ್ರಾರಂಭಿಸಲು ಸೂಚಿಸಿದೆ.
ಅಲ್ಲ, ಬಟ್ ದಿಸ್ ಇಸ್ ಕಂಪ್ಯಾಷನೇಟ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್.
Under this notification itself, she is appointed.
under the notification which is cancelled.
Which is the notification?
The recommendation annexure which I have referred, annexure G.
ಅಲ್ಲ, that is recommendation ಬಿಡಿ. Where you say it was by virtue of a notification.
Yes.
Where is that notification?
Notification I have not produced, but resolution.
From what I have read from the previous order, it seems like he has sought for appointment on compassionate ground. Yes. Where is the question of issuing notification there?
Her husband was not a permanent employee.
Correct.
She has not completed the probation.
Ah.
That is not independently considered by the competent authority, Jilla Panchayat. Annexure N may kindly be seen. High Court direct ಮಾಡಿದಂತೆ directly they appoint.
Annexure N appoint ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. Learned AGA takes notice for respond number 1. ಇದು ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ಗೆ ಮತ್ತೆ ಗ್ರಾಮ ಪಂಚಾಯತ್ಗೆ ಯಾರ ಅಪೇರ್ ಆಗಿದ್ದಾರೆ?
ಕೃಷ್ಣಮೂರ್ತಿ.
ಡಿ ಕೃಷ್ಣಮೂರ್ತಿ. Learned counsel Shri D Krishnamurthy is directed to take notice for response number 2 and 3. Issue notice to respond number 4.
Please.
Learned counsel for the petitioner is directed to serve 2 sets of copies of the petition along with annexures on learned counsel for response number 2 and 3 and a copy on the learned AGA. Next para. The appointment of the 4th respondent as peon with the 3rd respondent Gram Panchayat shall be subject to the final outcome of this petition. Mr. Krishnamurthy.
My lord, I appear for the petition, my lord. 2 weeks time may be granted.
Yes.
We have to take steps on respondents number 10 and 17.
4 weeks time is granted for taking steps. However, in case the steps are not taken within a period of 4 weeks, the petition shall stand automatically dismissed without reference to court. No
such address written 10 and 17. Third time process.
Ten and 17.
Oblige, my lord.
What is the matter about?
My lord, this is regarding some benefit given to the petitioner. Some benefit was given to the petitioners in fixing up their pay long back. That was challenged actually. That was challenged in the petition. The petition was disposed of by this honorable court, while an order at Annexure G, page 53, my lord, whereby this honorable court has given some direction at page 88, my lord. I avoid para 5, page 88. Ours is the grievance. Grievance could appropriately considered by the board, notwithstanding the efflux of time. The petitions are disposed of without prejudice to the contentions of the petitioners, which they may raise by way of an appeal before the corporation, and the inordinate delay in filing the appeal is explained by the fact that the petitioners were before this court in the first instance, and it is only at this point of time the petition is taken up for final hearing, and therefore there is no fault on the part of the petitioners in seeking to pursue their remedy. The board shall consider their appeal if such an appeal is filed by the petitioners, and the same may be dealt with in accordance with law. The petitioners shall, if they are so inclined, file an appeal within 15 days from the date of receipt of the certificate copy.
That order was passed in the year 1997. That order was passed in the year 1997. Annexure C. Annexure C, the previous order was passed in the year 1997. ಆಮೇಲೆ ಏನಾಯ್ತು?
ರಿಟ್ ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡಿದ್ವಿ. The petition was disposed of.
It was disposed of in the year 1997.
No, my lord. The petition was disposed of in the year 2011.
12th of September 1997.
One second, my lord. My
Annexure C ನೋಡಿ ಸರ್.
Annexure C is in the year 1997, my lord.
ಅದಾದ್ಮೇಲೆ ಏನಾಯ್ತು?
ಮತ್ತೆ there is one more petition was filed. Again, there was some order passed by the respondent number 1 that was challenged by way of petition number 20881 of 2005.
Where is that?
That is the order is that was disposed of in March 2011 at Annexure G, page 73.
That there are so many petitioners, so many other petitioners are there.
There are 22 other petitioners. They are all actually formal respondents. There are 22 respondents, out of which 20 are formal respondents. They are also the employees.
No. The writ petition is filed by Mr. Bhimsen, Vanaja, and so many other people. Even respondent adರಲ್ಲಿ. Are you a party petitioner?
Bhimsen ಮಾಡೋದ್ರಲ್ಲಿ ನಾನು respondent.
ಮತ್ತೆ?
In this case, Bhimsen is the respondent. I am the petitioner. There were altogether 3 orders of this honorable court, my lord.
Ratna Kumar, Glory, Rosalind. Glory, Rosalind. Ratna Kumar. You are respondent.
Yes, sir. The latest order of this honorable court is at Annexure N, my lord, page 111.
That is first respondent.
First respondent is board of directors, my lord. Notice is served.
For apprentices under training, and they were working on daily wage basis. Thereafter, they were appointed as junior assistants in the first respondent petition and as mechanics in this, whereas the petitioners were regularly recruited in the corporation much prior to the appointment of the said respondent and were seniors, indicator of junior assistants. The grievance could appropriately be considered by the board, notwithstanding the effects of time. The petitions are disposed of without prejudice to the contention of the petitioners, which they may raise by way of an appeal before the corporation, and inordinate delay in filing the appeal is explained by the counsel.
The latest High Court order is Annexure N, page 111. to 128, my lord. Your lordship may kindly see page 127, running page, last para. Para number 11, for the reasons stated above, this court sets aside the impugned resolution dated 23/12/2011 and impugned order dated 19/1/2012. This court directs the board to re-decide the appeal after giving an opportunity of hearing to both the parties. This exercise shall be carried out and completed by the board on or before 30th September 2015. In case the petitions are aggrieved by the decision of the board, they shall be free to challenge the same by filing a petition. Accordingly, I filed a representation dated 17/8/2015 at Connection P.
ಮತ್ತೆ ಬೋರ್ಡ್ ಕಳ್ಸಿದ್ರು.
ಮತ್ತೆ board ಹೋಯ್ತು madam. My representative for the board and the connection due has been issued at page 140.
So the order that was passed in your favor was set aside.
Why it was set aside, giving direction to the board to reconsider my petition.
Yes.
And pass an appropriate order by giving cogent reasons. Same order is passed without giving any additional reasons or any fresh grounds. My lord. That order is under challenge before the honorable court in the present petition.
Now you have attained the age of superannuation also.
Long back, my lord.
Both of you.
Even the respondents 10 and 17 are also now retired. I have taken steps for them, my lord. My one submission, my lord. All the
ಏನು ಉಳಿದಿದೆ ಈ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ?
My lord, I have to get substantial amount of arrears, my lord. Substantial amount, which is which will be in the range of about a few lakhs of rupees, 8 to 10 lakhs, my lord. My lord, may I make a submission, my lord?
Yes.
In this case, the contesting the respondents are only 1 and 2. That is the board of directors and the MD, my lord. Then there are all other, that is 3 to 22 respondents are formal respondents. That all other respondents have been served, but none have been represented before this honorable court. Your lordship may kindly notice the.
Now that you will be taking a risk. If you want to take that risk, you file a memo.
For one more time, give me an opportunity to take steps, my lord. Let us. They are their present address. They both
finally
retired, my lord.
A week's time is granted.
Kindly give me 2 weeks, my lord.
To take steps in respect of response number 10 and 17. I have 2 weeks.
My oblige, my lord.
The petition was admitted. Today I received a copy of the application. And previous date it is admitted. The petition was admitted.
The reason is I've worked 12 years in Sayadri College of Engineering. I have resigned in the year 2/11/2020. From that day, they had told me that 1 month notice is to be given.
You are not filed objection.
I have filed an objection. It was heard and the petition was admitted.
Sorry.
And interim prayer also sought in respect of similar relief, which is mentioned in the application. It was declared by the on the
For permission.
Yes, I have filed a detailed objection to the main.
IA for permission.
I moved to the relieving letter because I was working under AICT. And in AICT, my faculty name is linked to the Aadhaar number. Without them giving my relieving letter, I cannot apply to any other college. So from 2/11/2020, they have given all my duties to another lecturer. I have handed over, I have also produced a certificate. Now I do not have a job. If I go to any other college and apply, my Aadhaar link is linked to that college. That is why they are taking time and they are not giving me my relieving letter. I'm not asking for any other things. I'm just asking.
What is the prayer in this petition?
I want my relieving letter. The second thing is.
That is the main prayer.
Not the other benefits also.
What is the main prayer?
The main prayer is my relieving letter. Along with that, from April to November 2020, they have reduced my salary during the Corona period, which was against their own UGC certificate.
That we will consider. Why are you not giving the relieving letter?
My lords, kindly sit in prayer. Ready. Ella kodlike ready.
but still they are not agreeing to withdraw the.
I'll make one submission.
I am ready to give whatever the prayer which they sought in the petition. I am ready to give all the. Kindly see the prayer. Because the matter was referred to the mediation center, which we have agreed for everything. Kindly see. Page 7. Page 7 of the repetition. Return the original certificate which we have already given.
Relieving
Give the petitioner his relieving experience letter, which we are ready to give. There is no problem. Pay the petitioner full and final settlement of salary areas for the month of April 2020 to up to date. That also we are ready. Salary for the month from 2020 up to date. Gratuity, leave, encashment benefits, other dues as per the letter. That also we are ready. Withdraw the claim of rupees 19,42,040 mentioned in the reply letter. So and so. That also we are ready. Now what they say is that revised salary, seventh pay commission, whatever the salary which we are paying earlier, whatever the due amount which we are ready to give even today also. One thing is the salary back is now ready, but they are not agreeing.
I'll make one submission. In November 2017, they were giving me gross salary is basic plus DE. But what they have done is from April 2020, they have taken gross basic only. DE is not shown. They have taken various amounts. The reason is because if I come for gratuity, they're just telling me we'll give you 6 lakhs. 6 lakhs is no amount at all, Your Lordship. They have to give me according to the revised pay scale is what I'm asking.
That is
all is my. Let them give me, let the Honorable Court say revised pay scale. I will just point out where the revised pay scale in their own objections in Annexure A44. I will just point out at one page. Lordship, R44, they are respondent.
Rejoinder ಅಂತ ಹಾಕಿದ್ದೀರಾ ನೀವು? Rejoinder ಅಂತ ಹಾಕಿದ್ದೀರಾ ನೀವು?
ನಾನು ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದೇನೆ. ರಿಜಾಯಿಂಡರ್ ಹಾಕಿದ್ದಾರೆ. ಅವ್ರು ಏನ್ ಮುಂಚೆ ನಾವು ಏನ್ ಸ್ಯಾಲರಿ ಕೊಡ್ತಾ ಇದೀವಿ ನಾವು ಡಿಡಕ್ಟ್ ಮಾಡಿದೀವಿ ಕೊರೋನಾ ಪೀರಿಯಡ್. ಆ ಡಿಡಕ್ಷನ್ ಕೂಡ ತೆಗೆದು ಅವ್ರಿಗೆ ಏನ್ ಸ್ಯಾಲರಿ ಕೊಡ್ತಾ ಇದೀವಿ.
Statement of objections is bigger than their petition. ಹೇಳಿ.
It is their objection.
Yes.
They have put all the
yes.
Regarding R44.
Page number.
R44, page 247 of their objections. Page 247. And also my rejoinder, Annexure A14, page 39, maybe compare it. I just want to compare my rejoinder, page 39, Annexure A14 and R44. I just want to show how they have got a difference in salary. That is only my only grievance. Page 39, Annexure A14. Now, previously, if you see Annexure A14, this is November 2017 salary, page 39 of my rejoinder. At that time, they were giving me gross basic in 2017, 51,910.
July 2016.
November 2000, even July 2016 is okay. Okay, July 2016. Also, page 39, 51, the previous page, if you go to, gross basic is 51,910. November 2017. In that, you see that gross basic is 51,910 and DA is 29,848. Very nicely, this is calculated in March. But if you see in their objections, salary slip page, Annexure R44, the salary slip for March 2020. Here, basics, the gross basic comes to 55,070. Actually, gross basic I was getting 51,070, but in 20 I get only 55,070. There I was getting DA 29,848. So actually, my gratuity is calculated as gross basic plus DA. But here they are not ready to calculate my My
Gross basic is 51,910
yes, plus
during November 2017.
17.
Ah.
But here they have reduced in March 2020. Gross basic is 55,070. See the third row.
55,070.
They have reduced it.
Where they have reduced it? It is more.
That is very minimal.
Huh?
Very minimal. From November 17 actually to 2020, I should be getting much higher. And if you calculate gratuity is actually basic plus gross basic plus DA. Here there is no DA, it is made as variable allowance. There I was getting nicely gratuity is gross basic plus DA, but here they are cutting my DA.
Where is the component of dearness allowance here?
They have not given. Actually, it is as variable allowance, but they are not giving it to me. It is 16,521 is supposed to be DA, but nicely they have changed it to variable allowance, and they are not giving me now gratuity is basic plus DA. They are just misguiding me. That is why they are telling, yes, we will give you 6 lakhs and you keep quiet. I am saying, according to the November 2017 structure, calculate. I'm not asking too much. Whatever reduced salary from March to November, give me in the rate of November 2000 salary. And till now, I do not have my relieving letter. I could not apply to any other college. Enhanced salary. That is what I'm asking, and my relieving letter. Only these 3. If it is, I will dispose of it. It can be disposed.
Let them put it in record, my lords, whatever
No,
the
your
grievance. Because, my lords, nothing is there in the pleadings. Kindly see the pleadings. For the first time, they are taking it.
I have asked in my pleadings itself. I have.
Kindly see the pleadings, my lords, in the writ petition.
Yes, I will show you.
Kindly see the pleadings, my lords.
I say the
How the salary is reduced, there is nothing on record. Kindly see the writ petition pleadings.
Project paragraph 18. Without any valid reason of my pleadings, respondent number 1 reduced the salary of the petitioner for the months from April 2020 to October 2010, except August 2020, in spite of instructions from ASAT New Delhi and PTU Belgaum. The salary for the month of November 2020 was not yet paid. The respondent 1 cannot shirk from paying salary to the petitioner. It is a vested right under Article 14 and 16, as well as Article 300A of the Constitution.
No, where is the one that you pointed out now?
In my prayer also, I have to pay the petitioner his full and final settlement of salary.
Huh? No, but where is the ground? The one that you pointed out now.
This is the ground I am relying.
It is not stated. That is why he is asking. You go on making changing your stand inconsistent with the grounds that you have raised. What can they do then?
Your Lordship, rejoinder again I have filed. Reduced amounts paid during lockdown. 10th, third page 3 of my rejoinder.
When did you file rejoinder?
Rejoinder I filed on 6/7/2021.
ಯಾವುದು ಇಲ್ವಲ್ಲ rejoinder? Huh?
In the rejoinder only I have pointed out the 39th page and I have compared.
There is no rejoinder here. ಅವ್ರದ್ರಿ ಅವ್ರದ್ದು
Rejoinder mine.
ಕೆದಿಲಾಯ
Yes, mine. Page 3. And this for reduced amounts paid during lockdown. Again, I have benefits to be received by the petitioner, arrears and gratuity. Page 3, the second 8th para. The respondent submits that arrears has not been paid and 6th pay has been implemented from April 2011. The petitioner received fixed DA only 30% in 2016. However, the DA prevailing in 2016 was actually 125% as per government order ED Bengaluru dated 24/3/2020 marked as annexure A13. The respondent has stated that only basic and AGP are mandatory components of salary. They have not mentioned about yearness allowance and other allowances, which are also mandatory components of salary. The respondent has deliberately reduced the salary for the month of October 2020 by wrongfully referring AICT norms so that the gratuity amount could be reduced drastically. By merely changing the terminology of yearness allowance to variable allowance in the salary statement.
This is the only aspect that remains to be considered.
Only aspect remains to be considered.
I'll play my reply, my lords.
ಅಲ್ಲಪ್ಪ ಈಗಾಗಲೇ ಹಾಕಿದಾರಲ್ಲ ಅವರು.
For that
And you have
reply.
huh?
I'll just show the
Only that
my
point.
lords, in my statement of objection. We have also withheld the amount of salary which is being given in excess to the petitioner. My lords, so whatever the salary which was paid earlier, which was excess, that I have mentioned in my pleadings.
ಆಯ್ತು, ಇವಾಗ please give her the giving the relieving letter immediately. We will consider.
Letter ಕೊಡಕ್ಕಿಂತ ಮುಂಚೆ ಅವರು ಕೆಲವೊಂದು ಫಾರ್ಮಾಲಿಟೀಸ್ ಕಂಪ್ಲೈ ಮಾಡಬೇಕು.
We have gone 2-3 times to the
No. He is not agreeing. My lord, certain formalities has to be complied. What are the formalities I have called out in my statement of objection for which they are not ready? Kindly see, my lords, which I have stated in my statement of objection. What are the formalities which has to be complied? My lords, kindly see. Here. Page 17 of my statement of objection. Page 17. In a para number 22. VGST project fund of rupees 30 lakhs was sanctioned to Mr. Saranya Raj EC department on 28/4/2015. Due to unavoidable circumstances, he had resigned from the service on 29th April 2015. The copy of the VGT grant sanction letter also is fully shown. Under these circumstances, the project gets handed over to the head of the department who has to supervise the project and ensure the completion, either assigning a coordinator or taking the role of coordinator. Project was further assigned to Dr. Ashwath Rao. This is the petitioner. Considering his experience and exposure with a premium institution, the petitioner took up the project as coordinator on 11/8/2015 by signing a performer for change of VGST program coordinator. Thereby, he is an authorized coordinator for the project. Copy of the performer for the change of VGST project. Therefore, petitioner claims that he has been forcefully assigned the coordinator role for this project is baseless. The first installment of 10 lakhs was sanctioned on 16/4/2015, and petitioner spent the sanctioned amount towards the project. Copy of the sanction order dated is produced. However, the project progress is not up to the mark, since further installment was delayed by funding agency. As a coordinator, he has failed to complete the project within the given time. Since it is a government of Karnataka funded project, insurance institution is answerable to the Department of Information Technology to complete the project one time with full objective of the project. The project coordinator, the petitioner, was asked to submit the affidavit along with the progress of the project on for the release of second installment 10 lakhs. As per the norms, either he had to be in service till the release of the fund or new coordinator may be nominated with the consent of VGST. Regarding the above principle, requested the petitioner orally and same was communicated into HOD EC department to sign the affidavit to be submitted to VGST. The petitioner sent an email on 15/12/2020 refusing to sign the affidavit. The copy of the affidavit and email letter dated 15/12/2020 are produced. Petitioner has not requested for release of his original document was in service.
Ian, what is it that you want now?
Now, my lords, for the affidavit, he has to give his consent.
No, we will see it later. You please release give the release.
Your Lordship, I will just make one mention. In the affidavit,
we will see. The first respondent. Sahyadri College of Engineering and Management is hereby directed to issue relieving letter to the petitioner. Stop. The comma forthwith, full stop. However, it is made clear that the relieving letter being issued to the petitioner is subject to the final outcome of this writ petition. Full stop. If the petitioner is liable on any counts to the first respondent institution, comma, the petitioner shall not seek equity on the ground that a relieving letter is already issued to him. Yes.
Please.
Next para. This is matter for final hearing.
Ready for final disposal. Short matter. Not so. One mistake my colleague has made in the last one. ಒಂದಿದೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದೀವಿ. ಸ್ಟೇ ಇಲ್ಲ, ನಾನು ಇರಲಿಲ್ಲ, ಸುಮ್ಮನೆ ಕೊಲೀಗ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಮಾಡಿದ್ರು. ಸ್ಟೇ ಇದೆ ಅಂತ ತಮ್ಮ ಮುಂದೆ ಹೇಳಿದ್ರಂತೆ. ಸ್ಟೇ ಇಲ್ಲ, ಪೆಟಿಷನ್ ಬರ್ತಾ ಇದೆ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗ್ತಾ ಇದೆ. ಬಟ್ ಐ ಆಮ್ ರೆಡಿ ಟು, ಇದೇ ನನ್ನ ಪ್ರಕಾರ ಇದು 5-10 minutes ಅಲ್ಲಿ ಆಗುತ್ತೆ. ತಾವು ತಗೊಂಡ್ರೆ ಫೈನಲ್ ಡಿಸ್ಪೋಸ್.
ಹೇಳಿ ಹೇಳಿ.
Petitioners are all candidates post of agriculture field office. Notification invited by the second respondent. They have all appeared for the preliminary examination as well as the main examination, and the interview conducted by the IBPS second respondent. Their names have been kept in the reserve list by Annexure C, page 101. Page 101. Item number 2. This does not guarantee provisional allotment to recruitment by the participating banks in the event of participating banks providing further vacancy.
Page 101. Annexure?
Annexure C4. Page 101.
Combined result for online main examination and interview for recruitment of specialist officers.
Adರಲ್ಲಿ ಕೆಳಗಡೆ bottom ಅಲ್ಲಿ 2, item number 2. This does not guarantee provisional allotment to recruitment by the participating banks in the event of participating banks providing further vacancies to April 2021, March 2022. The provisional allotment will be carried out from the candidates in the reserve list. However, if the vacancy is furnished by the participating banks during the validity period, owing to exigencies or otherwise, the candidates under the reserve list will be considered for the provisional allotment, and the reserve list will be expired automatically on 31/3/2022 without any notice. Thereafter, not the annexure E came to be issued. The validity of the set period, the undead vacancies have been notified. This is under challenge. Not the very same issue has been decided by this court in WP annexure H.
Page number?
Page number 161, starting page. The operative portion of the order, page 206. Reason I pass the following petition is allowed to the response of the to consider the case of the petitioners who are found eligible in the reserve list and offer them appointment if they are found to be otherwise eligible. This exercise shall be completed by the response 2 to 4 hearing as expeditiously as possible at any event within 3 months from the date of very good.
So we are asking for similar direction.
Yes.
Three submissions. Second respondent. Second respondent is a recruiting agency, banking recruiting. The notification is in page 19. This is dated 1/11/2020.
No, are you?
The case
Huh?
submission. 1/11/2020. Kindly see page 37 and 38. He has sought for appointment from Bank of Maharashtra and the recruiting.
37.
37 is dated 1/11/2020. The number notification is dated 1/11/2020. 38 may kindly be seen. Column 2, serial number 3. What the Bank of Maharashtra wanted from us in this recruit advertisement is 0. They did not want any person at all. What column 3? He is saying that he wanted to get employment there. We are the recruiting agency. What Bank of Maharashtra wanted from us was 0. The second notification, which my learned friend is now stating, is in page 109 annexure E. That is not done by me. I am Institute of Banking Personnel Selection. This is done by Bank of Maharashtra. I have nothing to do with this. When I advertised, Bank of Maharashtra did not want. So how am I? Second point. That is the first point. Second point is there is a direct judgment of the Supreme Court which says.
So it was not a participating bank.
Participating bank which did not indent for any candidates. So he is saying that he wanted from Bank of Maharashtra. Bank of Maharashtra did not want any recruitment when I advertised, but they advertised independently thereafter, for which I am not responsible. Number 1. Second submission. Supreme Court.
ಯಾಕೆ ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿದಿರಾ ನೀವು? It's the Bank of Maharashtra.
3 and 4.
That Bank of Maharashtra did it through respond number 4.
3 and 4, my lord.
Respond number 4.
In ಎರಡು submissions. ನಮ್ಮ ಪರವಾಗಿ R2 ಪರವಾಗಿ.
So even otherwise, even if this writ petition fails against you, it would continue against response number 3 and 4. That is your submission. That is your submission.
Second submission. Supreme Court says that second respondent is not an instrumentality of the state. And a writ petition.
Now, by this itself, it is clear that you are not in the picture.
Second
and prayer would not have been maintained against you.
There is no prayer. He has not made any prayer against you. And our third submission is Supreme Court says that second respondent is not an instrumentality of the state because there is no direct control, administrative control, economic control, no control over the second respondent by the state. So under Article 12, I don't know. Very clear. Nam mele IBPS mele inobru Bombay nal case agtade. Supreme Court says in para 23, it's very clear that I am not a state at all. Therefore, making me a party here without seeking for any relief against me. That too in the circumstances when the intent was not made against me. Therefore, any which way we look at it, I am not responsible so far as his grievances are concerned. Last submission. So far as that the ruling of this honorable court, the appeal hakiri, my lords had given a stay. Adenaytantandre eradu recruitment ayi. So ex parte stay was given by my lords on 31/2019 because I argued just 2 days back there. I remember the date. 31/2019. Second notification we made it on 1/1/2019, which was not brought to my lord's notice. So my lord thought that there is no notification. It is co-terminus. Once a notification kotre, it is co-terminus with 1 year or second note or one more notification, whichever is early. They did not bring this fact to my lord's notice that there is already a notification on 1/1/2019. A batch of people went to Supreme Court under Article 32, which was also not brought to my lord's notice. Then another batch came. My lord noticed that there is a notification, though they are reserved list. Why should they be suffering on that? The interim order, which remained till the end. The learned judge says, res judicata baralla. Yakendra, the Article 32 nalli limited noಡ್ತಾರೆ. The Article 226, they can remain one on same page simultaneously. We never contended that res judicata, that was a group of people, these are a group of people. So a question of res judicata, adikoskara we have challenged that on the ground. Wait list, we have also made a distinction between wait list and the reserve list. Wait list are the ones that the learned judges relied upon. This is a reserve list. Altogether, a different gamut of arguments that can be advanced on the wait list and the reserve list. So my friend may not get much strength from the judgment of the learned single judge because the facts are not identical. Completely different.
Allah, insofar as respondent number 2 is concerned, your argument may hold good. But is grievance in respect of respondent number 3 and 4.
ಅವ್ರಿಗೂ ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಬರಲ್ಲ. ಯಾಕೆಂತಂದ್ರೆ ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ 2 ನೋಟಿಫಿಕೇಶನ್ ಡಿಫರೆಂಟ್ ರಿಕ್ರೂಟ್ಮೆಂಟ್ ಏಜೆನ್ಸಿ. ಇದ್ರಲ್ಲಿ ಅನೆಕ್ಷರ್ ಎ ನಾನ್ ಕೊಟ್ಟಿರೋದು R2, ಅನೆಕ್ಷರ್ ಇ ಕೊಟ್ಟಿರೋದು R3. Recruitment notification is issued by
101 is issued by you. Annexure C4 is issued by you.
Yes, my lord.
That does not pertain to
No, what is challenging is annexure E 109. My learned friend is challenging.
That was issued by Bank of Maharashtra.
Maharashtra. So our judgment is you can't. My learned friend may not get straight because notifications are different banks are issued, and he could not have made me a party. He has to file an application to delete me, or I request my lord to pass an order so for PR cards. I appear only for R2. I have also filed objections, served the copy yesterday, and requested the registry to tag it to.
So we'll delete them then. You cannot have any grievance against them because they are not the recruiting agents for you.
Is made by the IBPS.
Huh?
C1 result list is passed by the IBPS.
C4.
Yes,
C4.
all that series now.
You are Nisha Tanwar, is it?
Tanwar is the
Petitioner number 5.
List na operate ಮಾಡಿ ಅಂತ ಅಷ್ಟೇ but operating that list how the annexure E came to be issued.
I cannot operate the list. I'm only recruiting. What are the else? I don't operate. If they ask, I give.
No, but they have participated in the examination conducted by you.
Yes, well, I don't dispute. I don't dispute this document at all. But the bank did not want any recruitment at all.
Why you are specifically saying Bank of Maharashtra?
Now they are the Bank of Maharashtra is also one of the participating.
Illa. According to them, no.
Can you page 20 note? Notification. The participating organizations. Bank of Baroda, Canara Bank, Indian Overseas Bank.
That's very notification. That is what he pointed out.
This notification, they have made an application for the post of agriculture field officers.
They have made an application. I don't dispute. Bank of Maharashtra is also part of the
participating bank.
But they did not want this kind of officers. That is agricultural field officer here. In page 38, my lords, my kindness. They didn't want. 00 ಬೇರೆ ಬ್ಯಾಂಕ್ಗಳಿಗೆ Bank of Baroda ಗೆ 6 ಬೇಕಿದೆ. Bank of Maharashtra.
I am asking you why you have mentioned only Bank of Maharashtra as respondent here.
Any further vacancy is notified by reserving reserve list ಅಂತ ಹೇಳಿರೋದು. ಅದನ್ನ ಆಪರೇಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಅವರು. Now they are going to by operating notification ಮಾಡಿರೋದು Bank of Maharashtra by changing the method of recruitment and entirely ಬೇರೆಯವರಿಗೆ ಕೊಟ್ಬಿಡ್ತಾರೆ.
ಹೌದಪ್ಪ, in respect of the post that you are talking about, Bank of Maharashtra did not participate. ಅಲ್ಲ, ಅಲ್ಲಿ ಹೆಸರಿರ್ಬೋದು that it is in respect of other posts, but in respect of the post that you are seeking for, it did not participate. It is in respect of other posts, but iదే post ge if there are other banks, why have you not implicated them as a respondent? If there is any other bank,
banks ಇದೆ
11 banks ಇದೆ, ಅದರಲ್ಲಿ ನೋಟಿಫೈ ಮಾಡ್ತಾ ಇರೋದು 100 posts ನೋಟಿಫೈ ಮಾಡ್ತಾರೆ Bank of Maharashtra by the 4th respondent. ಸರಿ, ಈನಲ್ಲಿ
one ನಿಮಿಷ, which is it this ಇಲ್ಲಿದೆಯಲ್ಲ page number 21 ನಲ್ಲಿ the name of the post agricultural field officer scale 1, that is what you are talking of. Huh?
Yes.
Which other banks have participated for this?
ಇಲ್ಲಿ 38 ಅಲ್ಲಿ ಬ್ಯಾಂಕ್
38
ಅಲ್ಲಿ ಬ್ಯಾಂಕ್ ಆಫ್ ಇಂಡಿಯಾಗೆ ಅಗ್ರಿಕಲ್ಚರ್ ಪೋಸ್ಟ್ ಅಗ್ರಿಕಲ್ಚರ್ ಫೀಲ್ಡ್ ಆಫೀಸರ್ ಕಾಲಮ್ 2 ನಲ್ಲಿ ಬ್ಯಾಂಕ್ ಆಫ್ ಬರೋಡಾ ಕೇಳಿದೆ, ಬ್ಯಾಂಕ್ ಆಫ್ ಇಂಡಿಯಾ ಕೇಳಿದೆ, ಕೆನರಾ ಬ್ಯಾಂಕ್ 43 ಕೇಳಿದೆ ಕಾಲಮ್ 2 ನಲ್ಲಿ. ಆಮೇಲೆ ಯುಕೋ ಬ್ಯಾಂಕ್ 22 ಕೇಳಿದೆ. ಒಟ್ಟು ಟೋಟಲ್ 71 ಜನ
ಕೇಳಿದ್ದಾರೆ.
ಕೇಳಿದೆ. ಟೋಟಲ್ 485 ಅಲ್ಲಿ ಡಿಫರೆಂಟ್ ಕ್ಯಾಟಗರೀಸ್ SC ST OBC EW. ಸೊ ಇವರು ಬ್ಯಾಂಕ್ ಆಫ್ ಮಹಾರಾಷ್ಟ್ರ ಎಲ್ಲ 0000. They did not want any recruitment so far as this position is concerned.
Why have you mentioned the Bank of Baroda only as a respondent here?
Maharashtra.
Yeah, Bank of Maharashtra.
By annexure E by the Bank of Maharashtra. Changing the method of recruitment first to 80-20 ittu.
They have never participated for that post.
That's the reason.
Matte
Usually not 80-20 ittu. Written examination only 80% of marks in the written examination and 20% of the marks in the
ಅದಲ್ಲ ಆ ಇದಕ್ಕೆ ಅಲ್ಲಿವರೆಗೂ ಹೋಗೋದೇ ಬೇಡ. As per this notification for that particular post, Bank of Maharashtra did not participate.
ಮಾಡಿಲ್ಲ ಈಗ ಫರ್ದರ್ annexure E ನೋಡಿ
ಅದು then it's a different notification.
That has been annexure C ನಲ್ಲಿ ಫರ್ದರ್ ವೇಕೆನ್ಸಿ ಬಂದ್ರೆ ನಾವು ರಿಸರ್ವ್ ಲಿಸ್ಟ್ ಆಪರೇಟಿಂಗ್ ರಿಸರ್ವ್ ಲಿಸ್ಟ್ ಅಂತ ಹೇಳ್ತಾರೆ. Reserve list operate ಮಾಡ್ತೀವಿ ಅಂತಾನೆ we have been putting a reserve list.
But not in respect of Bank of Maharashtra because they did not participate for that post. ಬೇರೆ ಬ್ಯಾಂಕ್ಗಳು ಯಾವ್ದು ಇಲ್ವಾ? ಮತ್ತೆ ಏನ್ ಮಾಡೋದು? ಬಟ್ ಇಲ್ಲಿ ಈಗ ಆ ಪರ್ಟಿಕ್ಯುಲರ್ ಪೋಸ್ಟ್ ಗೆ ಅವರು ಕಾಲ್ಫರೇ ಮಾಡಿಲ್ಲ. What is that other document you showed where Bank of annexure E page number 109?
Yes.
This is a recruitment notification.
By the bank themselves.
It's a new notification.
New notification. ಅದನ್ನು ಅವರು
ಎಲ್ಲಿದಪ್ಪ ರಿಸರ್ವ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ? They have not participated for that post. That is why they have issued this new recruitment notification. From where? It may apply to all other cases. No, on facts, it is clear that Bank of Maharashtra did not participate for that particular post. ಅದು ಎಲ್ಲಿ ಬರುತ್ತೆ? ಆ ಪೋಸ್ಟ್ ಗೆ ಅವರು ಅಪ್ಲೈ ಮಾಡ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ they have not participated for that post. Where is the question of reserve list? ಅದಕ್ಕೆ ಇವಾಗ ನಾವು they have directly notified instead of going through this agency. They have directly notified. You apply.
ಇನ್ನೂ ಟೈಮ್ ಇದೆ.
You apply. Reserve list operate ಮಾಡಕ್ಕೆ ಈ ಸಿಚುವೇಶನ್ ಅಲ್ಲಿ ಬರೋದಿಲ್ಲ because they did not participate for that particular post under that notification. Actually, there is a difference between this case, the one that you have cited, and the present case. Not on, if you are able to point out the same facts was noticed or argued, please point out. ಇದೆಯಾ
ಜಡ್ಜ್ಮೆಂಟ್ ಇಲ್ಲ ಹಾಕಿದೆ
ಅಲ್ಲ ಅದರಲ್ಲಿ ಈ ಫ್ಯಾಕ್ಟ್ಸ್ ಏನಾದ್ರು ಬಂದಿದ್ಯಾ?
ಎರಡು ಬೇರೆ ಬೇರೆ ಏಜೆನ್ಸಿ
ಟೋಟಲಿ ಡಿಫರೆಂಟ್ ಅಲ್ವಾ? You want to apply directive, apply. Perfect.
I'm for respondent numbers 3 and 4, my lords.
You adopt the same argument.
Yes, my lords. Yes, my lords. All arguments have been canvassed by the learned counsel for respondent number 2.
Yes, perfect. The petitioners are applicants to the post of agricultural field officer, bracket scale -1, close. In terms of the notification, date idea
1/11/2020.
dated 1/11/2020, comma, issued by the second respondent, Institute of Banking Personnel Section. Full stop. The grievance of the petitioners is that although they were informed individually that they have been kept in the reserve list subject to vacancies for the year 2021-22, comma, as per annexures C series. Stop. However, the third respondent, Bank of Maharashtra, has issued a fresh recruitment notification dated 30/8/2021, calling for the post of agricultural field officer, inter alia. Stop. Nekara. Learned counsel for the petitioner submits that the case stands covered by a decision of a coordinate bench of this court in the case of Akash Sethi and others versus Union of India and others in WP number 5317 of 2019, dated 16th of April 2021. Stop. Learned counsel submits that having noticed the reserve list and the terms and conditions stated therein, comma, the coordinate bench issued a writ of mandamus directing the respondents
Bank there banks.
You are not a party there?
Non party ಇದೆ. ನನ್ನ ಮೇಲೆ ಡೈರೆಕ್ಷನ್ ಕೊಡ್ಲಿಲ್ಲ. ಬ್ಯಾಂಕ್ಸ್ ಮೇಲೆ ಮಾತ್ರ. RRBs, regional rural banks.
To the respondents, that is regional rural banks who had participated in the notification, to consider the case of the petitioners who are found eligible in the reserve list and offer them appointments, comma, if they are found to be otherwise eligible. The learned counsel therefore submits that the third respondent, Bank of Maharashtra, could not have issued the new recruitment notification dated 30/8/2021 without operating the reserve list prepared by the second respondent, IBPS. Stop. The learned counsel therefore seeks similar direction as was given by the coordinate bench in the case of Akash Seth Supra. Full stop. Next para. For contra, learned counsel Shri A. Ravishankar, appearing for the second respondent, IBPS, submits that the third respondent, Bank of Maharashtra, was not a participating bank insofar as the post of agricultural field officer, bracketly scale 1, close, is concerned. Full stop. The learned counsel has drawn the attention of this court to Annexure 1 of the notification dated 1/11/2020 and in respect of the posts of agricultural field officer, bracketly scale 1, he points out that Bank of Maharashtra had not participated for the said posts. Stop. Therefore, the learned counsel submits that when Bank of Maharashtra had never participated for filling up the posts of agricultural field officer scale 1, the notification dated so and so, the very foundation of this writ petition is taken away. Stop. The learned counsel therefore submits that if the Bank of Maharashtra has issued a fresh notification, it is because it did not participate for the posts of agricultural field officer scale 1 in the notification dated so and so, and therefore the Bank of Maharashtra was free to issue a fresh notification. So, moreover, it is submitted that the Honorable Supreme Court, in the case of Rajbir Surajban Singh versus Chairman, Institute of Banking Personnel Selection, Mumbai, bracketly 2019, close, 14 SCC 189. Has clearly held that the IBPS is not a state under Article 12 of the Constitution of India, as there is no control by the government over the respondent over IBPS in the manner mentioned in the said judgment. Stop. Next para. Learned counsel for the third respondent adopts the arguments of the learned counsel for respondent number 2 and submits that Bank of Maharashtra did not participate for the post of agricultural field officer scale 1 in the notification dated so and so issued by IBPS, the prayer made in the petition cannot be granted. Stop. The learned counsel would further submit that the petitioners are free to apply as per the recruitment notification dated 38/2021. Stop. Next para. Having heard the learned counsels and on perusing the petition papers, this court finds that actually the case of the petitioners is not similar to the case decided by the coordinate bench in the case of Akash Sethi bracketal Supra. Full stop. The factual averments made by the respondents is not found in the decision in the case of Akash Sethi. Full stop. Therefore, this court is of the considered opinion that since the third respondent, Bank of Maharashtra, never participated in the recruitment process under notification dated so and so for the post of agricultural field officer scale 1, the question of operating the reserve list in respect of the petitioners under the notification would not arise. Full stop. Next para. Consequently, the writ petition stands dismissed.
Lodge one submission.
However, the petitioners are free to participate, are free to apply for the post of agricultural field officers in terms of the notification dated 38/2021 issued by the third respondent, Bank of Maharashtra, if the period for the notification is still open. Full stop. Yes.
I wanted to submit that the deadline was 19/9/21 for them to apply. They have already exceeded the deadline.
ಮುಗ್ದೋಗಿದೆಯಾ?
ಮುಗ್ದೋಗಿದೆ.
Page 130. 130. Last para, line 2.
ಇವಾಗ ಲಾಸ್ಟ್ ತೆಗೆದ್ಬಿಡಿ, ಅಲ್ಲಿ ಮೇಲ್ಗಡೆ ಹೇಳಿದ್ನಲ್ಲ, ಇವು ಸಬ್ಮಿಷನ್ ಸಕ್ಸಸ್ ಮಾಡುವಾಗ ದೇ ಆರ್ ಫ್ರೀ ಟು ಅಪ್ಲೈ ಅಂತ ಹೇಳಿದ್ನಲ್ಲ, ಅಲ್ಲೇ ಸೇರಿಸ್ಕೊಳ್ಳಿ. ಅಟ್ ದಿಸ್ ಜಂಕ್ಷರ್ ಇಟ್ ಈಸ್ ಬ್ರಾಟ್ ಟು ದಿ ನೋಟಿಸ್ ಆಫ್ ದಿಸ್ ಕೋರ್ಟ್ ದಟ್ ದಿ ಅಪ್ಲಿಕೇಶನ್ in terms of the notification dated 38/2021 issued by the third respondent, Bank of Maharashtra, was required to be submitted online from 1/9/2021 to 19/9/2021. Stop. Therefore, the window for application has been closed. All right.
Obliged, my lords.
I appear for the corporation.
Case
of the married daughter for compassionate appointment is rejected by improved endorsement at annexure A on the ground that the date of death of her father who was in service is prior to the amendment notification 9/4/2021. In substance, what they say is this amendment notification dated 9/4/2021 can be given only prospective effect. Since the date of death of the father is prior to 9/4/2021, you are not entitled for benefit of compassionate appointment. But my lord, my submission is this amendment dated 9/4/2021 was brought into effect, my lord, to make good the law. Subsequent to this honorable court striking down the expression of unmarried daughter from the relevant rules, the judgment of this honorable court is at annexure G, my lord.
So we wanted to say something about that in the division bench. You have not said that, Alva?
Actually,
No, but we had discussed.
It's just discussed, but on facts, your lordship have held in that case that the applicant therein had not approached the court with clean hands. Therefore, your lordship have rejected their claim.
ಬೇರೆ ಯಾವುದು ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಯಾವುದು ಅಡಿಷನಲ್ ಬರಲಿಲ್ವಾ?
That is also, my lords, in case of adopted daughter. Adopted daughter shall be treated on par anta heli hold madidare. But that is not applicable to the facts of this case. Lord, what is to be answered by this honorable court, my lord, here is whether when a law is struck down as unconstitutional, being taking away the rights and the fundamental rights guaranteed in the Constitution, it is struck down from the inception. It is void ab initio. Article 13 of clause 2 of the Constitution. But the state or any legislation.
Adre, the flip side of that argument would be that it would open, it would can it give a right to all such applicants to reopen their cases. Therefore, if we don't know balance madi, we'll have to give a decision.
Your lordship, see this scenario. This case, which is decided by Justice Nagapasan case, which I have quoted, my lord, here. Annexure G, page 20. At this point of time, my lord, this amendment was not got into it. This very exclusion of the word married daughters from the definition was called in question. There, this court not only struck down the rule, but also directed that she is entitled for compassionate appointment. Avaga e notification is there. So if now it is So when a law is struck down, it is struck down. More particularly, when a law is struck down for other reasons, it is different.
So at least in all such cases where the applications were pending as on that date, if the applications were pending as on that date, as on the date of that order.
Please.
The
date of the order is 15 December 20. My learned friend informed me that there is a judgment of division bench which says that this amendment notification is given retrospective.
Other, we want that. Though this issue came up and we wanted to pass an order, but under the peculiar facts and circumstances of that case, he is referring to our. Yardu. ಯಾವ್ದು ಎಲ್ಲಿ ಇಲ್ಲಿ ಪ್ರಿನ್ಸಿಪಲ್ ಬೆಂಚ್ ಅಲ್ಲ no because we also had an occasion to deal with that at Kalburgi bench, division bench.
But use these not substituted, therefore it dates back to the original date.
Although the problem is there are decisions of the Supreme Court itself which says if the authorities have considered it as per the prevailing regulations, no fault can be found with them. So
the Supreme Court decision says the policy which was prevailing as on the date,
correct,
that is the policy which has to be applied so far as compassionate appointment is concerned. But that will not come into deprive me in this case because of this reason.
Adikkene, so we'll have to make out a difference, at least protect those of the applications which were pending before the amendment came.
The very question is interpreted.
Allah, if it is decided, you please help your friend.
NC Santosh versus State of Karnataka.
Nodappa idre
2021 NC Santosh versus State of Karnataka. Not aware of the exact citation. 2021 6SC.
ಅಲ್ಲ ಇದ್ರಲ್ಲೂ ನಿಮ್ಮ ಮೊಬೈಲ್ಗಳಲ್ಲೂ ನೋಡ್ಬೋದು.
2020 volume 7 SCC Supreme Court judgment.
2021 7 SCC. I am not aware of the page number.
ಅಲ್ಲ ಮೇಡಮ್ ಹೇಳ್ತಾ ಇದಾರೆ, which is that one?
If NC Santosh is what is being referred by the counsel, because I can't see or hear it clearly, it is in 2020 volume 7 SCC 617.
2020 volume 7
617 SCC.
21, the Honorable Apex Court says that if the application is pending,
no, that is what I am saying.
As on that, the law which was prevailing as on that date shall apply.
That is what I said.
NC Santosh.
Your application was subsequent, is it?
My application is not prior to 9/4/2021. My application is the date of death itself.
Date of death is prior to the notification, my lord, the amendment, prior to the amendment, 26/11/2020. Death certificate. Annexure C is the date of death.
If this amendment is
page ಇದೆ ಎಷ್ಟು ಪೇಜ್ ಇದೆ?
date of death is 26/11/2020.
Correct. Your application was pending.
Application is on 2/7/2021. The amendment, my lords, is on 9/4/2021. Date of death is 26/11/2020. Date of death of petitioner's father is 26/11/2020. The date on which, my lords, this the judgment of this honorable court striking down, that is 15/11/2020. The amendment notification to make good the law, that is 9/4/2021. My application seeking compassionate appointment is 2/7/2021.
2/7/2021. Now, as per the amended law,
As per the amendment, they say death is prior to this amendment notification. 9/4/2021 now amendment got ಮಾಡಿದೀವಿ, bring ಮಾಡಿದೀವಿ, but the death is prior to this amendment notification, that is on 26/11/2020. Therefore, you are not entitled for the benefit. That's what they say.
how can you interpret it in that manner?
That is how, that is what they are saying.
Well, that seems to be the information or the understanding of the corporation to say that since the death was prior to the amendment coming into force, so therefore the rule that was prevailing as on that date, the death that occurred, this has to be considered. That
Rule as on the date of the application.
If that norm is followed, my lord, he
No,
will be entitled.
even going by the decision of the Honorable Supreme Court, the Supreme Court judgment of
NC Santosh's case considers that matter.
No, we have noticed even in this.
Plus, this judgment is reported, my lord, which your lordship is referring to now, my lord.
Of course. Allah, there we have no. Though this issue came up, we did not give a finding on that because we went on the facts of that case.
Facts of the case.
Your lordship.
But we have noticed the submission of the learned counsels that in the case of Director of Treasuries in Karnataka, in civil appeal number so and so, the Supreme Court had decided.
Well, that is reported in AF 2021 SC 5620.
Wherein it was held that at the relevant time when the deceased employee died and when the original writ petitioner made an application for appointment on compassionate grounds, the divorced daughter was not eligible for appointment on compassionate grounds, and the divorced daughter was not within the definition of dependent. Now, if the application is made within time, after the death of the employee, and if the application is made within time, after
Take the amendment notification.
Yes.
They cannot say that, sir.
Yes.
So that even applying the Supreme Court judgment,
What is the time frame within which the application has to be?
1 year.
1 year.
So as on the date
So
of
their application also is within time then.
Within time, my lord.
So as on the date of the application, the law has been amended.
Please, my lord. But
So that is applicable to.
one aspect the application does not consider, my lord, is that the applicant has not stated that she is a married daughter. She is living separately from her husband, or along with her husband, separately with her husband. In the application, there is no averment. Of course, this issue has not been considered. It's rejected only on the ground that she is a married daughter.
Therefore, no. You are free to consider the application.
Very well.
It could not have been rejected on this ground.
Very well.
For other grounds, you are free. You can reconsider this.
Very well. Very well. Lord, the judgment which your lordship was referring, my lord, in the Director of Treasuries is reported in year 2021 SC 5620, my lord. So the last occasion I had given a copy with the government advocate. I'm not sure if he's carrying it with him in this file, my lord.
ಇದೆಯಾ ಅಲ್ಲಿ ಕೊಡಿ.
Because I did not get the other point which was subsequent.
ಏನು ತೊಂದರೆ ಇಲ್ಲ. Your case comes within the amended provision.
Only says that the law which is prevailing as on the date of consideration of the
Correct.
As on the date they had considered my application, this amendment notification had to give effect.
Correct.
They could not have said that this is prior to amendment notification, therefore you are not.
It would have been different if you had made the application after the amendment and after the period of limitation prescribed. Yes. That would have been different. So you are within the prescribed period. Yes. This is taking note of the new amendment. Illa. Before that.
Last decision para 21. There is a remark that as on the date of considering the application, what was the law that shall be taken into consideration.
Well, perhaps the council is referring to the judgment as reported in SEC because para 21 is not here in the ARSC. So your lordship may kindly see that would be in para 7, my lord, of this Supreme Court judgment, my lord.
NC Santosh,
they're taking note of cognizance of the judgment in NC Santosh, para 7, my lord. The council is referring to 21, is not there in SC, so therefore I'm making this. They have called out the law laid out in para 17.
Para 19 millards of the NC Santosh judgment, applying the law governing compassionate appointed called out from the aforesaid judgments, our opinion on the point at issue.
One nimsha. ಯಾವ paragraph?
19.
Now ARSC ನೋಡ್ತಾ ಇದ್ರೆ para 7.
Applying the law.
Applying the law governing the compassionate appointment called out from the aforesaid judgments. Our opinion on the point at issue is that the norms prevailing on the date of consideration of the application should be the basis for consideration of claim for compassionate appointment. A dependent of a government employee in the absence of any vested right accruing on the death of the government can only demand consideration of his or her application. He is however decided to seek consideration in accordance with the norms as applicable on the date of death of the government employee. So the law which is prevailing as on the date of consideration of the application.
Again, here it's mentioned, my lord, that she is entitled to seek consideration according to the norms as applicable to date of death of the government employee.
ಇದರಲ್ಲಿ ಕ್ಲಿಯರ್ ಆಗಿದೆ ಬಿಡಿ. I don't think there is a need to go into these decisions also. Yes. The petitioner is before this court, aggrieved by the impugned endorsement dated 26/7/2021 at Annexure A, issued by the second respondent, issued by the third respondent, health officer, Mysore City Corporation, rejecting the application of the petitioner who had sought for appointment on compassionate terms. Full stop. Next para. The petitioner's father, late Sri Ramanna, was a Group D employee in the respondent, Mysore City Corporation. Sri Ramanna died on 26/11/2020. Leaving the petitioner as the only surviving legal heir, as the petitioner's mother had also predeceased her father. Stop. The petitioner who is married, made an application seeking appointment on compassionate grounds, in terms of a representation dated 2/7/2021. Stop. In the impugned endorsement, it is stated that since the petitioner's father died on 26/11/2020, in terms of Rule 3 of the Karnataka Civil Services, bracketally appointment on compassionate grounds. Correct? Yenadu?
Karnataka Civil Service Appointment on Compassionate Ground Rules 1986.
Close Rules 1966. 1996. 1996. ಅಲ್ಲ ಅಮೆಂಡ್ಮೆಂಟ್ ಬಗ್ಗೆ ಏನು ಹೇಳಿಲ್ಲ. ಹಾಕಿದ್ದಾರೆ. Yes. A married daughter was not entitled to seek compassionate appointment. Stop. It is also stated that although the said rule has been amended as on 9/4/2021,
Date of death of petitioner father is prior to 9/4/2021.
while enabling a married daughter also to seek appointment on compassionate grounds, however, since the petitioner's father died prior to the amendment, that is on 26/11/2020, the case of the petitioner cannot be considered. We'll stop. Next para. Then a counsel for the petitioner submits that a learned single judge of this court, a coordinate bench of this court, in the case of Srimati Bhuvaneshwari V. Puranik versus State of Karnataka and others, in WP number 17788 of 2018, dated 15th of December 2020, declared that the words unmarried, inward commas, preceding the word daughter, offends and violates Article 14 and 15 of the Constitution of India, and therefore the coordinate bench proceeded to strike down the offending portion and issued a direction to the state government to consider the claim of the petitioner therein for appointment on compassionate grounds. Stop. Consequent to the said directions issued by the coordinate bench, the rule was amended, and the word, commercially unmarried, prefixing prefixed to the word daughter was removed. And
married ಅನ್ನೋದು ಸೇರಿಸಿದ್ರು.
And the word married daughters was included in the definition of the word dependent, dependent, of a deceased government servant. Subject, of course, to the other provisions regarding the income criteria of the family. Then a counsel further submits that the impugned endorsement cannot be sustained since nowhere it is provided that the amended provision would apply only to such cases where the government servant died after the amendment was brought into force. Stop. The learned counsel would also place reliance on two decisions of the Honorable Supreme Court, namely Director of Treasuries in Karnataka and another versus B. Soumya Shri, AR 2021 SC 5620, and NC Santosh versus State of Karnataka and others. ಏನದು citation bracketly 2020 volume 7 SCC 617 content that the law as on the date of the application should be considered and not the date of death of the employee. Stop. Next para. Learned counsel for the respondent corporation would, however, contend that the application of the petitioner was required to be rejected on other grounds also, if not for the ground stated in the impugned notification, impugned endorsement. Stop. Next para. Having heard the learned counsels and on perusing the petition papers, this court finds that the application made by the petitioner seeking compassionate appointment is required to be considered in terms of the law prevailing as on the date of the application. Stop. If the application is made within the time prescribed in the rules governing the appointment on compassionate grounds, then the application is valid and is required to be considered in terms of the law applicable as on the date of the application. Stop. Next para. As noticed earlier, on facts, the date of the death of the employee is 26/11/2020, and the amendment was brought to the rules with effect from 9/4/2021. Stop. ಕೊಡ್ರಿ ಅದು ಇದು ರೂಲ್ಸ್ ಕೊಡಿ 1990. See that ಇದು period of limitation. Rule 5.
Rule 3, my lord.
Page 66 of my written petition.
In terms of Rule 5 of the rules the application is required to be filed within 1 year from the date of death of the government servant. Stop. The application of the petitioner is within the prescribed period. Stop. Therefore, the provisions of the amended rules is required to be applied in the case of the petitioner. So the application could not have been rejected on the ground that the petitioner's father had died before the amendment was brought to the rules. Stop. There is no such prescription as stated in the impugned endorsement. Stop. The prescription, as noticed herein above, is that the application is required to be filed within a period of 1 year from the date of death of the government servant in such form as notified by the government from time to time. Stop. Next paragraph. For the reasons stated above, this court proceeds to pass the following order. 1. The writ petition is allowed. 2. The impugned endorsement dated 26/7/2021 at Annexure A is quashed and set aside. 3. The second and third respondents are directed to reconsider the application of the petitioner stop. If the petitioner fulfills all the other criteria as stipulated in the rules, including the amended rules which has come into effect from 9/4/2021,
other criteria as stipulated in the rules, including the amended rules which has come into effect from 9/4/2021.
The respondents are required to pass necessary orders, as expeditiously as possible, and at any rate within a period of 2 months from the date of receipt of a certified copy of this order.
Obligation.
Appearing for petitioners, my lord. Appearing for petitioners, my lord.
Yes.
My lord, there is a office objection which is in page number 66 of petition. The petitioners' names are there: Manjunatha, Naveen Kumar, and Raghavendra, etc.
Huh?
The office objection related to
C.
office Annexure C in page number 66.
Annexure
My lord,
C.
On page number 66, petitioners' names are there, my lord.
Manjunath.
Manjunath,
Ambar.
Naveen Kumar, yes, my lords. So the office objections may be overruled and matter may be heard, my lord.
Yes, office objection is overruled. Yes.
My lord, there is a IA for dispensation of typed copy and translation copies. My lord knows Kannada, so allow me to not press IA number 1 dispensation.
Angalla, see, you know, the roster keeps on changing. That is why we have insisted that if there is any document in Kannada, then translation will be required.
No, my lord, this is voluminous and the KPSC is very hurried to publish its final selection list. If it happens so, the petitioner's right will be infringed.
Order on IA number 1 of 2022. This application is filed seeking dispensation of production of the typed copies, translated copies of all the documents that are in Kannada. So, the requirement of production of the translated copies are dispensed with for the time being. Yes.
My lord, petitioners are drawing teachers, applicants for the drawing teacher post. There are 3 types of diplomas which used to provide by Kannada University Hampi. Diploma in art master examination, diploma in drawing and painting, and specialization diploma in painting, which is generally called as a special diploma. My lord, but in the selection list, in provisional selection list, which was published by KPSC respondent number 2 on 25/11/2021, my lord, the qualification with the special diploma that has been excluded, just including a diploma in art master exam as well as diploma in drawing and painting.
This is a notification of the provisional list.
Yeah, my lord, this is the provisional list which has published, and they have not considered the specialization diploma course, which is long back. It is since from 2003, the course is in existence, and there are more than 3,500, 4,000 candidates are there who are of this
Sir,
qualification.
you can't point out from the provisional list if you had any grievance in respect of stipulation of the educational qualification. You should have challenged the notification.
No, my lord. For
the
that,
recruitment notification is of the year 2016.
Yes, my lord.
What are you doing from 2016 then?
They called for the objection in the provisional list, my lord. Which has published on 25/11/2021. For which they called for office objection. No, they called for the objection. We have
learned AGA takes notice for respondent number 1. KPSC ಯಾರ ಪೇರ್ ಹಾಕ್ತಾರೆ? ಅವರಿಲ್ಲ, ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್. KM Prakash. Learned Counsel Sri KM Prakash is directed to take notice for respondent number 2, KPSC. Learned Counsel Sri Nagaya is directed to take notice for respondent number 3. Learned AGA for response number 1 and 4. Kannada University.
Yes, my lord.
Ballari.
Yes, my lord.
Why you have filed this writ petition here in Bangalore?
No, my lord, this is the university which provides diploma certificates. All the courses which are
Certificates.
there, mean diploma certificates, the course diploma certificates.
All right. Issue notice to response number. Learned AGF for 1, 4 and 6. Issue notice to respond number 5. Learned counsel for the petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on all the learned counsels for the respondents. Yes.
My lord, interim prayer may be allowed, my
No,
lord.
sir.
Much obliged, my lord.
Yes.
Appear for the petitioner in this case, my lord. 3 days may be granted, my lord. Office objection.
A week's time is granted at the request of learned counsel for petitioner for complaints of office objections.
Appear for the petitioner in this case. Same may be 3 days may be granted. One certified copy furnished, my lord. 23 also, my lord. Same.
No, I appear for the applicant. I have already complied the office objection. On 17/2/2022, there are 3 objections. One is
I
appear for the respondent in this matter.
Yeah, you have received copies.
My lord, I have received copies, my lord. I have got my paravised remarks yesterday, my lord. I'll file my objections in a week's time.
Then a counsel for the respondents. Submits that he has received copies of the writ petition. However, the learned counsel prays for some time to file objections.
Objections, ma'am.
Stop. 2 weeks are granted for filing statement of objections.
But they are recovering my family pension. The matter covered by general division bench. Family pension cannot be recovered and all those things. That can be considered. Interim order of stay of the recovery. Recovery of family pension may be stayed until further order. The inquiry was dropped.
Recovery, na?
How recovery ಮಾಡ್ತಾ ಇದ್ದಾರೆ?
What has been? The next para. The respondents are directed not to precipitate the matter for recovery of pension, family pension granted to the petitioner, till the next date of hearing.
Subsequently, it has been raised, my lord. However, my lord, I will produce in 2 days, my lord. For timing, my lord, I may not rely on for issuance of notice, my lord. I just argue on the other aspect. My lord, sir, this matter is for writ of mandamus. Prayer is at page 18, my lord.
Mandamus interim prayer.
Interim prayer, my lord, my lord, I am working under came to be retired in 2019, and I was working in the HMT company, and my statutory benefits are still pending, and also the salaries also.
Sorry, what is the interim prayer?
Interim prayer is, my lord, there are several funds has been granted by the Union of India to the HMT, my lord, only for the purpose of for clearance of the gratuity and
direct the respondents to file detailed project report.
Yes, my lord. Funds released by the central government.
Let us see.
What is other?
Learned Central Government Council is directed to take notice for response number 1 to 6.
1 to 6 ma'am. Yes, ma'am.
ROC. Learned Council Sri T. Rajaram is directed to take notice for response number 7. ಇದು ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ಕೌನ್ಸಿಲ್ ಸಿಬಿಐ ಸಪರೇಟ್ ಆಗ ಸಿಬಿಐ ಸಪರೇಟ್ ಆಗಿದಾರಾ? ಪ್ರಸನ್ನ ಕುಮಾರ್. Learned Council Sri T. Prasanna Kumar P. Prasanna Kumar is directed to take notice for response number 8. Issue notice to response number 9 to 11. Learned Council for the petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on the learned counsels for the respondents.
9 to 11 ಗೆ MS ನಾರಾಯಣ ಅಂತ ಅಪೇರ್ ಆಗ್ತಾರೆ.
The petitioner is also permitted to serve a copy of the repetition on learned counsel Sri MS Narayan, who had appeared for response number 9 to 11 in some other matters. Yes.
After 2 weeks.
Huh?
After 2 weeks.
Yes. In the meanwhile, office objection shall be completed. Learned counsel for the petitioner submits that court fee has been paid. Office to verify. Yes. What is your prayer? What is your prayer in the representation?
Representation, annexure C, complaint. Before the second respondent authority, cooperative society, that there is some mismanagement has happened in the society. It has held a preliminary inquiry. Report is at annexure C, page 18, and annexure F, page 31. Page 31. Apologies, report page 36. Annexure G. It is the report when I complained before the second respondent, it was referred to fifth respondent. Fifth respondent authority has held a detailed inquiry even after issuing notice to the office society. It has held that there is mismanagement. So necessary action, further action has to be taken. Thereafter, no action is being taken. 1/10/2021 is the last date. Afterwards, it's been 5 months. Thereafter, annexure H has been representation. Even 3 representations. Annexure H, annexure J, annexure K, page 54. 13/12/2021 is the last representation. Third, in the kindly similar annexure G, page 36 report. Page 40 is the finding with respect to first charge. ಮೇಲ್ಕಂಡ ಆಡಳಿತ ಮಂಡಳಿ ಸದಸ್ಯರಿಂದ 68,40,000 ವಸೂಲಾತಿಗೆ ಕ್ರಮ ಅಗತ್ಯ. Respect to second charge also similar order is passed. Page 46. ವ್ಯವಹಾರ ಜರುಗಿರುವ ಅವಧಿಯಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸಿರುವ ಎಲ್ಲಾ ಆಡಳಿತ ಮಂಡಳಿ ಸದಸ್ಯರ ವಿರುದ್ಧ ಕಲಂ 29C ಅಡಿ ಕ್ರಮವಿಡಬಹುದಾಗಿರುತ್ತದೆ. And third also similar page 48.
ಆಯ್ತು.
Thereafter, this is addressed to third respondent authority. Afterwards, no action.
What would the third respondent do?
Well, third respondent is authority plus to take further action to initiate either 29C proceedings or to initiate subsequent proceedings against them. Hold an inquiry. Preliminary inquiry has been held, but whoever is responsible, they have not issued notice to them or nothing has happened.
Learned AGA. take notice for all the respondents. Learned counsel for the petitioner is directed to serve a copy of the petition along with annexures on the learned AGA. The learned AGA is required to secure instructions from the third respondent, joint registrar of cooperative societies, as to why no further action is taken consequent to the report submitted by the assistant registrar of cooperative societies, fifth respondent.
Inspector, senior.
Senior inspector.
Senior inspector, page 48.
By the fifth respondent. Annexure Gina, dated 1/10/2021. Stop. Release this matter on 31st of March. Week's time is granted for complaints of office objections.
So in case petition.
Special order. Huh? Huh? For correction of the interim order dated 23/2.
My lords, my lord directed the revenue authorities to revert back the entries which have been subsequently made after filing of the writ petition.
There shall be an ad interim order of stay of the operation and execution of the impugned orders dated so and so till next date appears.
After that, my lords, my lords submitted to the honorable court that my lords, during the pendency of this writ petition, my lords, subsequent orders, those orders, my lords, revenue entries have been changed to the respondents, private respondents' names. Thereafter, my lords, the lords directed the revenue authorities to revert back the entries, my lords, and the government advocate also has noted down on the docket, my lords.
That cannot be a correction, sir. A correction.
Private respondents have already changed the names in the RTC, my lords, and selling the properties.
Innೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಐ ಕಾಂಟ್ ಮೇಕ್ ದಿಸ್ ಕರೆಕ್ಷನ್. ಏನಾದ್ರು ಅಲ್ಲಿ ಟೈಪೋಗ್ರಾಫಿಕಲ್ ಎರರ್ ಏನೋ ಇದ್ದು ಕರೆಕ್ಷನ್ ಅಂತಂದ್ರೆ ಐ ಕ್ಯಾನ್ ಕ್ಯಾರಿ ಔಟ್. ದೇರ್ ಇಸ್ ನೋ ಸಚ್ ಟೈಪೋಗ್ರಾಫಿಕಲ್ ಎರರ್ ದಟ್ ಯು ಆರ್ ಟ್ರೈಂಗ್ ಟು ಪಾಯಿಂಟ್ ಔಟ್. How can I remember all those things and say ತಪ್ಪಾಗುತ್ತೆ? IA number 2 of 2022 stands disposed of, granting liberty to the petitioner to file a fresh interlocutory application seeking the relief of reverting the revenue entries made consequent to the impugned orders dated 28/4/2016 at Annexure A and 11/1/2022 at Annexure B, before the bench having roster. Yes. ESCOM.
Served on 21st March.
Not there.
I see. Learned counsel. Submits that a copy of the petition has been served in the office of the managing director of the respondent ESCOM, and an acknowledgement is found in the presentation form to this effect. Yes.
Petitioner is challenging election.
Your वापस को पड़े
Petitioner is a physically challenged person. ESCOM called for applications for appointment as revenue assistant from the physically disabled persons in the year 2007. The petitioner is appointed as a revenue assistant. The appointment order is also produced. Thereafter, on medical ground, he remained absent. He submitted a representation. He was
ಯಾವಾಗಿಂದ
15/11/2014 he submitted representation. He is unable to attend. He is suffering from thereafter he reported back along with the fitness certificate. Fitness certificate I have produced at 61, page 61. 25/8/2018, the MD issues a direction to the chief engineer, page 63. Second paragraph. ಪ್ರಧಾನ ವ್ಯವಸ್ಥಾಪಕರು ಕೋಲಾರ ವೃತ್ತದಲ್ಲಿ ಆದೇಶ ಸಂಖ್ಯೆ 19/11/2017 ಬೃಹತ್ ಕಾಮಗಾರಿ ವಿಭಾಗ ಕೋಲಾರ ಗುತ್ತಿಗೆ ಕಂದಾಯ ಸಹಾಯಕರಾಗಿ ನೇಮಕಗೊಂಡು ನಂತರ ಬಂಗಾರಪೇಟೆ ನಿಯೋಜನೆಗೊಂಡು ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿದ್ದ ಎಂ ಕೃಷ್ಣಮೂರ್ತಿ ದಿನಾಂಕ 25/9/14 19/4/2018 ಕಾಮಲೆ ಕಾಯ್ದೆಯಿಂದ SNR ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಚಿಕಿತ್ಸೆ ಪಡೆಯುತ್ತಿದ್ದ ಕಾರಣ ಕಚೇರಿಗೆ ಗೈರು ಹಾಜರಾಗಿರುವುದಾಗಿ ತಿಳಿಸಿರುವುದರಿಂದ ಸದರಿಯವರ ಅವಶ್ಯಕತೆ ಮತ್ತು ಸದರಿಯವರ ದೈಹಿಕ ಸದೃಢತೆಯನ್ನು ಪರಿಶೀಲಿಸಿ ನಿಯಮಾನುಸಾರ ಮುಂದಿನ ಕ್ರಮ ಕೈಗೊಳ್ಳುವಂತೆ ತಿಳಿಸಲು ನಿರ್ದೇಶಿಸಲಾಗಿದೆ. In the meantime, similarly placed contract employees approach the sample code for regularization of their service in view of the notification by the ESCOM. The sample code allowed the request and granted relief of regularization. Lords, the petitioner was directed to be taken to duties on 17/11/2018 Annexure P, page 173. Last 2 lines, ಕಾಯಿಲೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಚಿಕಿತ್ಸೆ ಪಡೆದುಕೊಂಡಿರುವುದಕ್ಕೆ ಜಿಲ್ಲಾ ವೈದ್ಯಾಧಿಕಾರಿಯಿಂದ ದೃಢೀಕರಣವನ್ನು ನೀಡಿರುವ ಕಾರಣ ಸದರಿಯವರ ದೈಹಿಕ ಸದೃಢತೆಯನ್ನು ಪರಿಶೀಲಿಸಿ ಕರ್ತವ್ಯಕ್ಕೆ ತೆಗೆದುಕೊಳ್ಳಲು ಆದೇಶಿಸಲಾಗಿದೆ. Thereafter, there was a correspondence on how he should be paid and from what account he should be paid.
Joined. You joined duties.
I reported for duty on 9/9/2019. Thereafter, an endorsement came to be issued on 19 December 2020, stating that he cannot be taken back to duty. 181 days.
ಎಂ ಕೃಷ್ಣಮೂರ್ತಿ ಗುತ್ತಿಗೆ ಕಂದಾಯ ಸಹಾಯಕರಾದ ನೀವು ದಿನಾಂಕ 25/9/14ರಿಂದ 19/4/2018 ಸುಮಾರು 3 ವರ್ಷ 7 ತಿಂಗಳವರೆಗೆ ಗೈರು ಹಾಜರಾಗಿರುವುದರಿಂದ ಉಲ್ಲೇಖ 1ರಲ್ಲಿ ನಿಗಮ ಕಾರ್ಯಾಲಯ ಕಾವೇರಿ ಭವನ ಬೆಂಗಳೂರು ಪತ್ರದಲ್ಲಿ ಕ್ರಮ ಸಂಖ್ಯೆ 5ರಲ್ಲಿ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ದಿನಾಂಕ 10
What is the interim order you are asking for?
What's the commissioner for physically disabled person?
What is the interim order that you are asking for, sir?
Commissioner for disabled person has passed a interim order directing regularization of services.
No. That is not permissible, sir. He has no such power. The AGA takes notice for response number 1. Anyone appearing for this state commission? Response number 2. Persons with disabilities. Issue notice to respond number 2. Learned counsel. Bescom ಮತ್ತೆ KPTC ಎರಡು ಕಾಪಿಯರ ಯಾರಿದ್ದಾರೆ? Learned counsel Sri H.V. Devraj is directed to take notice for response number 3 to 7. Learned counsel for the petitioner is directed to serve 2 sets of copies of the petition along with annexures on learned counsel for response number 3 to 7 and a copy on the learned AGA. Yes.
The alternative interim prayer I was directed to be taken back to duties. Let them continue me on contract basis.
ಬರೋದಿಲ್ಲ ಹಂಗಾಗಲ್ಲ.
What officer, sir? What officer, sir? What officer, sir? What officer, sir?
Criminal petition. Criminal petition case. Sir, ಎಷ್ಟೊತ್ತು ಲಿಸ್ಟ್ ಆಗಿದೆ 1948 of 22. ಸೀರಿಯಲ್ ನಂಬರ್ 62 ಇದೆ.
ಮೇಕಲ ಹೋಯ್ತಲ್ಲ ಅದು ಬ್ರಾಂಚ್ ಹೋಯ್ತು. What officer, sir?
1978 of 22.
What officer, sir?
ನಾನು 24 ಹೇಳಿದ್ದೀನಿ. 13 ಸರ್. ನಿಮಿಷ ಲಿಸ್ಟ್ ತೋರಿಸ್ತೀನಿ.
ಸರಿನಾ ಅಂತ ಫಸ್ಟ್
ಮಾಡ್ಕೊಂಡು
Other side is not here. I will not adjourn the matter. I don't adjourn matters like that. Huh? Yes.
There are 2 petitions filed so far as continuance beyond the age of retirement under the university statute till the academic year. There are some interim orders have been passed around 5 to 10 matters. Under your last. Another 5 minutes, 2 petitions. The interim order is under the Bangalore University. The lordships are aware of it. Till the academic year, they are entitled to continue. Unless or until there is an interim order, they take their own time. By that time, they will retire.
Early every morning, I am allowing the advocates to give their memos. I am allowing them to file memos and asking them to list the matters. Whoever is on record, let them move the memos. Sir. Yes. Yes. Passover.
Number 7, that's it, correct? For a writ of certiorari and mandamus number. Petitioner is a teacher by qualification. It made several representation to the school authorities, also backed up by several letters from former ministers and government mayor to consider the representation. Also, respondent number 2 has failed to consider the same and appointed her as a teacher, stating the reason that she is appointed as a head cook of the institution and not as
there was no interim order. The interim prayer.
There's no interim prayer.
ಬೆಳಿಗ್ಗೆನೆ ಹೇಳ್ಬಿಟ್ಟಿದ್ರೆ I would have issued notice. Learned AGA takes notice for response number 1 and 2. Issue notice to respond number 3. Learned counsel for petitioner is directed to serve 2 sets of copies of the writ petition along with annexures from the learned AGA. Dictation.
Dictating order. Party.
Yes. The petitioner who is serving as professor in the Department of Orthopedics in the first respondent, Bangalore Medical College and Research Institute, bracketly DMC for short. Is before this court. Seeking to set aside the final combined seniority list of professors dated 28/8/2019, annexure A, semicolon, final combined seniority list of professors dated 22/2/2018, and seeking a writ of mandamus to prepare the combined seniority list of professors working in the institute on the basis of total length of service in the teaching cadres commencing from date of entry into service as lecturer or assistant lecturer Assistant Professor. And thereafter, to undertake the exercise of selection for appointment to the post of Medical Superintendent and all other administrative posts falling vacant during the pendency of this writ petition, on the basis of the combined seniority list could be directed to be prepared. Stop. Next para. Some of the undisputed facts are that the petitioner and the third respondent, along with several other successful candidates, were appointed were selected and appointed by the Karnataka Public and appointed as lecturers in the Department of Health and Family Welfare, Government of Karnataka. Department of Medical Education. Department of Medical Education. Lastly,
the successful candidates were selected by the KPSC and appointed as lecturers in the Department of Medical Education.
And appointed by the Government of Karnataka in the Health and Family Welfare Services, Department of Medical Education, by order dated 29/5/2000. Stop. The petitioner contends that in terms of the seniority list, a combined merit list published by the Karnataka Public Service Commission, the petitioner was at serial number 18, while respondent number 3 was at serial number 39. However, the Bangalore Medical College was converted into autonomous institution. And the services of all the teachers who are teaching at the Bangalore Medical College were given an option either to be absorbed in the autonomous institution or to continue their services in the Department of Medical Education. Stop. This is government order.
Page 44, 40.
44. 54.
50. Page 54.
The government of Karnataka issued a government order dated 26/8/2008 at Annexure E according sanction for the permanent absorption of the teaching staff of Medical Education Department who are then working in the Bangalore Medical College. And converted into an autonomous Bangalore Medical College and Research Institute with retrospective effect from the date on which the Bangalore Medical College was converted into an autonomous Bangalore Medical College and Research Institute, subject to the conditions stated therein. Stop. It is also an admitted fact that both the petitioner as well as the third respondent opted to be absorbed into the autonomous Bangalore Medical College and Research Institute. Stop. ಅದಕ್ಕೆ ಬರ್ತೀನಿ ಆಮೇಲೆ. Next para. The immediate reason for the petitioner to have filed this writ petition is that in terms of the cadre and recruitment rules of the teaching cadre of the institute, the administrative post of the dean cum director has opened up for being filled up, and in terms of the impugned final combined seniority list of professors dated 28/8/2019 which was in fact revised from the earlier final combined seniority list dated 22/2/2018, the third respondent is placed over and above the petitioner, although the petitioner was senior in terms of the merit list prepared during the time of their appointment. Stop. Next one. Learned Senior Counsel Shri A.S. Ponnanna, appearing for the petitioner, submits that as per the cadre and recruitment rules of the teaching cadre of the institute, as found at Annexure G, candidates are required to be selected based on seniority cum merit from amongst the teachers in the autonomous institution. So for that purpose, it is provided in the rules itself that the 5 senior-most willing professors as per the cadre-wise seniority list of professors shall be considered by the governing council for appointment. So, the Learned Senior Council submits that on a plain reading of the said provision, it is clear that there is no provision for preparing a combined seniority list. So, in this regard, the Learned Senior Council would further draw the attention of this court which is the other provision that you pointed out. 10.
Oh, sir, bylaw 21.
Stage, madam, ಈಗ
In this regard, learned senior counsel to further draw the attention of this court, which is the
to the bylaws of the Respondent Institute. Which is named as Memorandum of Association. Of the Bangalore Medical College and Research Institute, Bangalore. ಎಲ್ಲಿದೆ?
Bylaws of the Bangalore Medical College and Research Institute.
In this regard, learned senior counsel to further draw the attention of this court to the bylaws of the Respondent Institutes, which is named as
found at Annexure F. So, in fact, Annexure F is the Memorandum of Association of Bangalore Medical College and Research Institute, Bangalore, and the bylaws form part of Annexure 2 of the Memorandum of Association. Stop. Clause 21 of the bylaws reads as follows. ಅಂತ ಹಾಕೊಂಡು ಪೇಜ್ ನಂಬರ್ 105 ಅಲ್ಲಿ ಕ್ಲಾಸ್ 21 ಪೂರ್ತಿ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡ್ತೀನಿ. Learned senior counsel would therefore submit that the bylaws would require the director cum dean of the institute to prepare and maintain a gradation list in respect of each of the categories of employees and publish the same on the 1st of January every year. Stop. There is no requirement of preparing a combined seniority list. Stop. The learned senior counsel places reliance on a decision of the Honorable Supreme Court in the case of State of Andhra Pradesh versus Dr. N. Ramachandra Rao and others, bracket ಅಲ್ಲಿ 1990 clause 3 SCC 590. To buttress his argument that under similar circumstances, in the case of medical profession, the Honorable Supreme Court has held that there are various specialities in medical profession, and it is generally accepted that they are not of equal importance or utility. However, the promotions are allowed on the basis of the respective specialities and the availability of promotional vacancies in such specialities. The Honorable Supreme Court has noticed that a junior with relatively less important specialty may be fortunate enough to get quick promotion than his senior in a different specialty. It was therefore opined that the juniors who get accelerated promotion on account of fortuitous circumstances depending upon their specialty and availability of vacancies in such specialty should not be allowed to march over their seniors for appointment to administrative posts. It was further held that any advantage gained by juniors on such fortuitous circumstances of having some specialty and promotion should not impair the rights of their seniors for promotion to posts where specialty or teaching experience is not called for. The seniority determined in order of specialty should not therefore be the basis for promotion to administrative posts. Full stop. It was finally held that any rule providing for the contrary may be vulnerable to attack on the ground of arbitrariness. Stop. Next para. For contra, learned counsel for the third respondent would submit that the petitioner, like the third respondent, voluntarily accepted the absorption rules contained in the government order dated 26/8/2008, which also provides that on their absorption into the Bangalore Medical College and Research Institute, the absorbed teaching faculty shall be allowed to carry their existing designation and grade comma, as found in clause 1 in the government order. Stop. The learned counsel submits that the petitioner would not dispute the fact that as on the date of absorption into the institute, the petitioner was in the cadre of assistant professor, comma, while the third respondent was in the cadre of professor. Stop. That being the position, comma, it is contended that the third respondent has been functioning as professor in the institute not only from 26/8/2008, comma, but also even prior to the absorption, comma, as the third respondent was promoted as professor on
20th of August 2007.
20th of August 2007. Stop. The learned counsel would therefore submit that even as per the rule of seniority cum merit, comma, the third respondent is definitely senior to the petitioner in the cadre of professor, and the combined seniority list prepared, impugned, has been prepared taking into consideration the length of service of the professors from the date of their appointment into the cadre. Stop. The learned counsel seeks to place reliance on the following decisions. 1. Indu Shekhar Singh and others versus State of UP and others, bracket 2006, 8 SCC 129.
Judgment, seniority list. Judgment reading.
M. Ramchandran versus Govind Ballabh and others, bracket 1999, 8 SCC 592. 3. Dr. C. Renuka Prasad. Dr. C. Renuka Prasad versus State of Karnataka and others, ILR 2000 Karnataka 2256. ಇದರಲ್ಲಿ ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್?
ILR para 28.
Para 28.
That is directly on the point. They will lose their seniority.
Next para. the learned counsel for the third respondent to submit that it has been held in the above cited judgments that the continuous service rendered by the employees concerned, single unit counts, on similar posts, closed comma, which would mean posts which are available having been legally created or born on the cadre forms the basis for determination of seniority. Further, having regard to the decision in the case of Dr. C. Renuka Prasad, bracketed Supra, the learned counsel submits that it is by now well settled that the employees having accepted the terms of absorption are bound by the terms of the absorption rules. Full stop. Learned counsel submits that when it is clear from the government order dated so and so that the petitioner and the third respondent were absorbed as per the cadre in which they were working as on the date of absorption. Namely, the petitioner having been absorbed in the cadre of assistant professor and the third respondent having been absorbed as professor, the length of their service in the cadre is required to be taken into consideration. Full stop. The third respondent having been absorbed into the institution from the year 2008 in the cadre of professor, is definitely senior to the petitioner who was promoted to the cadre of professor as on
2/4/2016.
2/4/2016. Stop. It is therefore submitted that no fault could be found in the combined seniority list or gradation list prepared by the respondent institution. Full stop. Huh?
7 of the exhaustion.
At this juncture, learned senior counsel for the petitioner would point out to clause 7 of the government order dated 26/8/2008, which provides that separate orders will be issued in consultation with the Department of Personnel and Administrative Reforms in the matter of seniority, service, and conduct rules. Stop. It's further submitted that there is no dispute to the fact that separate orders in this regard was never issued. Stop. Next para. Third, the learned senior counsel for the petitioner. Huh?
DPR, what they are following, I have produced. DPR guidelines.
ಇದು NMC ದು ಮತ್ತೆ ಇದರದಲ್ಲ ಏನೋ ಹೇಳಿ.
My lord, my submission may be taken.
ಆಮೇಲೆ ಸಿವಿಲ್ ಸರ್ವಿಸ್ ರೂಲ್ಸ್ ಗೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿ.
Where is that?
DPR they have submitted around.
Memo ಅಲ್ಲ. Further, it is pointed out that the government of Karnataka, DPAR, issued the Karnataka Medical Service, practically teaching and technical personnel in medical and dental colleges, close. Innondu bracketally recruitment, another bracket amendments, close rules, 2001. In terms of the powers conferred under subsection 1 of section 3 read with Section 8 of the Karnataka Civil Services Act, 1978. So, in the note, along with the amended schedule, it is provided that open and commas, notwithstanding anything contained in the Karnataka Civil Services bracketally seniority close rules, 1957, seniority dash say SC dash seniority inter se seniority of professors shall be determined on the basis of the total length of service put in cadres of lecturers, assistant professors and professors. So, this rules were notified on 29th of June 2001. So, further, the Learned Senior Counsel would point out to the regulations of the National Medical Commission which are known as teachers' eligibility and minimum qualifications in medical institutions regulations dash 2021. Stop. At regulation 3.10, it is provided that appointments to administrative posts in government institutions, including the in-charge arrangements, amongst eligible candidates, shall be based on inter se vertical seniority based on entry date of entry into the institution bar service.
The government service in that. Because this is the draft. I provided the gazetted copy. Copy shall remove. The only change is instead of service, it's become government service.
ಅದು ಚೇಂಜ್ ಮಾಡ್ಬಿಡಿ ಹಂಗಾದ್ರೆ ರೆಗ್ಯುಲೇಷನ್ 2022 ಅಂತ notified on 14th of February 2022. 3.10 ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಬಾರ್ ಗವರ್ಮೆಂಟ್ ಸರ್ವಿಸ್. Heard the learned senior counsel.
I'm sorry, my lord. I am appealing for respondent number 1, my lord.
ಯಾವ್ದೊಂದು ಆಗ್ತದೆ learned counsel. Shri Prashant DR
please
appearing for the first respondent institution. Submits, while adopting the arguments of the learned counsel for respondent number 3, that
My first submission was with regard to page number 75, my lord, appointment of medical.
That even for the purpose of determining the seniority of 5 senior most willing professors as provided in the C&R rules of teaching cadre of the institute at annexure G, comma, their length of service in the cadre is required to be considered. Stop. When there is no dispute to the fact that the third respondent has been absorbed into the services of the institute in terms of the government order dated so and so. And when admittedly the writ petitioner was promoted into the cadre of professor in the year 2016, comma, the final combined seniority list prepared, impugned, comma, cannot be faulted. Stop. Moreover, it is submitted that the regulations of the National Medical Commission, which is pointed out by the learned senior counsel, comma, even if accepted, comma, can have prospective effect and cannot be made applicable to a final seniority list prepared way back in the year 2018 and 2019. Stop.
Page number 75 appointment of medical regulation 20. Appointment of medical they have prepared as per the C&R rules.
Appointment of medical, paramedical and administrative staff.
Based on this only we have two, my lord, the appointment of dean and director, medical superintendent, professor, associate professor, assistant. Based on this only we have prepared anta namma antage.
It is further submitted that the seniority list has been prepared in terms of in terms of clause 20 of the bylaws of the respondent institution. Stop.
Rules and regulations, bylaw. Page number 64 in the startup.
In terms of the Bangalore Medical College and Research Institute, comma, in terms of the rules and regulations -2013 of the respondent institution. It is submitted that the clause 2 of clause ಅಲ್ಲ ಇದು ರೂಲ್ಸ್ ಅಲ್ವಾ ಇದು
ರೂಲ್ಸ್
ಅಲ್ಲ sub clause 2 of regulation 20 of the 2013 regulations would provide that the senior most professor of the institute shall be appointed as a principal to assist the dean and director and shall be placed in charge of the duties.
ಅದರ ಮೇಲ್ಗಡೆ the appointment of dean and director. That the appointment of the dean and director, comma, shall be done by the vice chairman of the governing council on the recommendation of the selection committee constituted for this purpose in accordance with the rules of recruitment, which shall be based on MCI regulations. Stop. Next paragraph. And bylaw 21 senior. Page number 105.
ಅದೇ ಅವ್ರು ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡಿದ್ರಲ್ಲ ಅದೇ ತಾನೆ
ಅದೇ ಸೇಮ್
that has already come.
Please.
So ಹಂಗಾರೆ ಅದು bylaws ಅಲ್ಲ, it should be rules and regulations.
ಅಲ್ಲ ಅದು bylaws.
ಅದು ಬೇರೆನಾ?
That is bylaw.
The memorandum of association. Rules and regulations.
ಅದ್ರ ಜೊತೆಗಿರೋ bylaws.
And bylaws separately. All three are separate, but I have produced the direction. Page number.
ನಾವು page 64 ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ. Page 64 ಅಲ್ಲಿ ರೂಲ್ಸ್ ಅಂಡ್ ರೆಗ್ಯುಲೇಷನ್ಸ್
ಮೂರು ಇದೆ. ಮೂರು ಇದೆ. ಮೆಮೊರಾಂಡಮ್ ಆಫ್ ಅಸೋಸಿಯೇಷನ್ ಇದೆ, ರೂಲ್ಸ್ ಅಂಡ್ ರೆಗ್ಯುಲೇಷನ್ಸ್ ಇದೆ, ಅಂಡ್ ಬೈಲಾಸ್ ಇದೆ. Page 94 is the bylaws. Continuous copy ಆಗಿರೋದ್ರಿಂದ ಒಂದೇ ತರ. (54) is the memorandum of association. 64 is the rules and regulations. 94 is the bylaws.
Third, the learned senior counsel, Shri J.S. Ponnanna, for the petitioner, comma, learned counsel, Shri M. Subramanya Bhatt, for respond number 3, and learned counsel Shri Prashant B.R. for respond number 1 institution, and perused the petition papers. Stop. Next para. Having regard to the provisions contained in the memorandum of association, comma, the rules and regulations dash 2013 and bylaws of the institute, comma, both annexed to the memorandum of association, and more particularly having regard to clause 21 of the bylaws, which provides for seniority. It is clear that seniority of the employees in each category shall be determined by order of merit in which they were selected for appointment to the cadre in question. Stop. Most importantly, it is subject wise in respect of teaching cadres. Stop. We cannot miss the fact that the list brought before this court is in the background of appointment to the administrative post of dean cum director. Dean cum director.
Superintendent.
Dean and medical superintendent.
Medical superintendent, not dean.
Interim prayer. Participate in the selection process to the post of medical superintendent, which falls.
Allah, we will go directly to this C&R.
Subsequent dean cum director.
Dean cum director.
Page 111. Subsequent dean cum director.
Subsequent andre
first bit.
That's first bit. So let us not confuse ourselves again. Subsequent andre adyen subsequent.
Yes.
The first dean anta barutte. Amele subsequent dean.
Correct. There is no dispute that this is category 2. Subsequent dean cum director. Allu astene. First one allu astene. It is the same thing.
Same requirements.
Medical superintendent, subsequent principal.
Dean cum director, principal, and medical superintendent. All administrative posts.
Dean cum director of the institute, as provided under the C&R rules of teaching cadre of the respondent institution. Stop. Unlike the consideration for promotion to the next cadre, we are concerned with the appointment to an administrative post of the institute. So, therefore, the learned senior counsel is right in his submission that what is required to be considered is as per the provisions contained in the C&R rules. Stop. The requirement is that candidates for the said post shall be selected based on seniority cum merit from amongst the teachers in the same autonomous institution. Stop. In this regard, 5 senior most willing professors, as per the cadre-wise seniority list of professors, shall be considered by the governing council for the said appointment. Stop. It is also not disputed that as per the requirements of the regulations and bylaws, no combined seniority list. In each cadre is required to be prepared. Full stop. The requirement under subclause 2 of clause 21 under the heading seniority of the bylaws of the institution also clearly provides that the seniority of the employees in each category, singular counsel, shall be determined by order of merit in which they were selected for appointment to the cadre in question. Stop. It is also clear that it shall be subject-wise in respect of teaching cadres. Stop. Therefore, the enunciation of the Honorable Supreme Court in the case of Dr. N. Ramchandra Rao, bracketly Supra, would squarely apply to the facts and circumstances of this case. Stop. It was noticed by the Honorable Supreme Court that regard being had to the fact that in the medical profession there are several subjects and several specialties, and each subject have their own relative importance. Stop. It was noticed that there may be some subjects or specialties which may be more important when compared to others. Stop. It was also noticed that the promotional avenues would open up in each of the specialties and for various reasons it is found that in some specialties the promotional avenue may not open up so easily, as in the case of the other specialties. Stop. Having noticed all these vagaries, the Honorable Supreme Court held that Honorable Supreme Court opined that the juniors who get accelerated promotion on account of fortuitous circumstances, depending upon their specialty and availability of vacancies in such specialty, should not be allowed to march over their seniors for appointment to administrative posts. Stop. Any advantage gained by juniors on such fortuitous circumstances of having some specialty and promotion should not impair the rights of their seniors for promotion to posts where specialty or teaching experience is not called for. Stop. The seniority determined in order of specialty should not therefore be the basis for promotion to administrative posts. Full stop. It was finally declared that any rule providing for the contrary may be vulnerable to attack on the ground of arbitrariness. Full stop. Next paragraph. In the considered opinion of this court, the observations of the Honorable Supreme Court are aptly applicable to the facts and circumstances of the present case. Stop. We are dealing with an appointment to an administrative post in the present case. Stop. Therefore, having regard to the requirements contained in the C&R rules of the respondent institution for considering appointment to the post of dean cum director and other administrative posts, comma, the requirement is that 5 senior most professors should be taken into the zone of consideration. Stop. The concept of preparing a combined seniority list for this purpose is not provided for. Stop. In fact, comma, even for the purpose of promotion, comma, this court did not find any such requirement of preparation of a combined seniority list. Stop. Nevertheless, comma, for our purpose, comma, it is sufficient to notice that as per the requirement found under the C&R rules for appointment to administrative posts, comma, more particularly the dean cum director, comma, 5 senior most professors in each category are required to be considered. Stop. The clarification, the clarificatory note contained in the Karnataka Medical Service, practically teaching and technical professional personnel in medical and dental colleges, close recruitment, separate bracketally, amendment, separate bracketally, comma, rules 2001 makes it clear that notwithstanding anything contained in the Karnataka Civil Services bracketally seniority, close, rules, 1957. Inter se seniority of professors shall be determined on the basis of the total length of service put in cadres of lecturers, assistant professors and professors. Stop. This again is reflected in the teachers' eligibility qualifications in medical institutions regulations, 2022 of the National Medical Commission in clause 3.10, which again provides that for the purpose of appointment to administrative posts in government institutions, inter se vertical seniority based on date of entry into the institution for government service is the requirement. So, on the plain reasoning, as pointed out by the Honorable Supreme Court in the case of Dr. Ramchandra Rao, it is clear that when the petitioner along with the third respondent were appointed under an order dated so and so, and the petitioner was placed higher in the merit list when compared to the third respondent, and on account of some fortuitous circumstances, if the third respondent gained accelerated promotion, the right of the petitioner for being appointed to an administrative post cannot be scuttled on the ground that the third respondent was promoted as professor much before the petition. Stop. It is this circumstances that was aptly noticed by the Honorable Supreme Court, more particularly for the purpose of appointment to administrative posts. Stop. Next para. For the reasons stated above, this court proceeds to pass the following order. 1. The petition is allowed in part. Two, it is hereby declared that the two impugned final combined seniority lists dated 22/2/2018 and 28/8/2019 shall not be taken into consideration for the purpose of appointment to the administrative posts of the first respondent institution, more particularly the upcoming vacancy in the post of dean cum director of the first respondent institution.
All three administrative.
I leave it at that. The last more particularly bada.
One more particularly to administrative post.
Administrative post bantala.
ಇಲ್ಲ ಅದು ಬರಲ್ಲ ಡೀನ್ ಕಮ್ ಡೈರೆಕ್ಟರ್ ಬರಲ್ಲ ಮೋರ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಬರಲ್ಲ ಎನಿ ಒನ್ ಆಫ್ ದೀಸ್ ತ್ರೀ
ಅಲ್ಲ ಅದಕ್ಕೇನೆ ಆ ಮೋರ್ ಪರ್ಟಿಕ್ಯುಲರ್ಲಿ ನಾ ತೆಗೆದ 3 the first respondent institution the governing council alla who has to make this appointment? The governing council.
Appointment
governing council.
Appointment
as per the C&R rules, it is the governing council. The governing council of the first respondent Bangalore Medical College and Research Institute is hereby directed to consider the 5 senior most professors in various specialties or categories based on their length of service commencing from the date of their appointment.
Lordship may say as per the merit list. As per the merit list. As per the merit list.
Allah, he is disputing whether the authenticity of that one.
I am not saying that list. I am saying as per the merit list.
Total length.
I am doubting the authenticity. I have disputed it.
There must be a merit list. As per that merit list, because length of service allows on there. Five professors they have to select. As per the merit list. That is the whole case, and that is what the Supreme Court says. It must be as per the merit. Because not the DPR also says.
Because even the KPSC has not issued a reply, and the RTI is saying that we do not have the list.
The Lordship may say in terms of what is laid down above this.
NMC rules
laid down above the judgment.
ಅದು ಸೇಫ್ ಅನ್ಸುತ್ತೆ ಯಾಕಂದ್ರೆ ಇಲ್ಲಿ ಡೇಟ್ ಆಫ್ ಎಂಟ್ರಿ ಇಂಟು ಸರ್ವಿಸ್ ತಗೊಂಡ್ರೆ ಐ ಎಂಟರ್ಡ್ ಮಲಾಟ್ earlier to the petitioner.
ಅಲ್ಲಲ್ಲ ಇದಕ್ಕಲ್ಲ entry into the government service. That is why they have put institution bar government service.
Even our as far as the first appointment is concerned, Lord, I entered the service 1 day prior to the petitioner.
Adalla the anga that also is covered. You know how that has to be.
It has to be a select list.
Yes.
As per the NMC guidelines, which recently there, as per the NMC 22/22.
But it is to be taken into account. Institution hatra ಇದೆ selection list.
We will prepare the seniority list as per the NMC rule.
Not KPSC, they will destroy this after 10 years. It is the rules. But the government will have it institution. Government ಕಳಿಸಿರ್ತಾರೆ selection process ಮಾಡಿ KPSC ಕಳಿಸ್ಬಿಟ್ಟು. Yeah, that is how we have got it. We have got a certified copies.
The governing council of the first respondent is hereby directed to consider the 5 senior most professors in various specialities or categories based on their length of service commencing from the date of their appointment.
Based on the merit list furnished by the KPSC to the government, and on the basis of which the appointment orders were issued to the petitioner and the third respondent here.
Sentence may be added. As far as I am concerned, but I am disputing the merit list. Hello, ಒಂದು ಕಡೆ ಹೇಳಿದ್ರೆ ಸಾಕು.
ಆಯ್ತು, ಅವರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಒಂದು ಲಾಸ್ಟ್ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಸೇರಿಸ್ಕೊಂಡು the learned counsel for the third respondent disputes the merit list at annexure B. B for Bangalore.
Yes.
Annexure B furnished along with the memorandum of petition.
Please.
Connected matter. ಎಲ್ಲಿದೆ? ಓ, connected with. ಆಯ್ತು, ಅಲ್ಲಿ ನಾನು ಸ್ಟಾರ್ಟಿಂಗ್ ಅಲ್ಲಿ ಬರೆದ್ಬಿಡ್ತೀನಿ ಕಾಮನ್ ಆರ್ಡರ್. ಸಿನ್ಸ್ the issues raised in both these writ petitions are common, the matters were clubbed, heard together and disposed of by this common order.
For the respondent, your lordship. Lordship, any date may be fixed for hearing, lordship.
13.
The date, the matter was coming up in B group. Hearings are completed, the date can be fixed.
This matter for final hearing on.
Come in B group only, completed.
In my list, final hearing orders, final hearing matters will come up earlier. What do you want?
I'll leave the better ones. I'll leave it, please.
For final hearing on 5th of April 2022. Full stop. IN number 1 of 2022 is according to 4th.
Lordship, we have engaged the senior counsel in this matter. It may kindly be had on 5th only, your lordship. 4th, he has some inconvenience.
6th agboda?
6th agboda, Swami.
6th,
please. Oblige. Huh? 30th. ಏನು matter ಇದು?
Granted ಕೊಟ್ಟಿಲ್ಲ ಅಂತ second round of petition. It's of urgency. The 30th, 31st.
At the request of learned HCGP, release this matter on 31st of March.
Date may be fixed, my lord, because my lord, we're seeking for warrant for my lord. The managing director for the cooperative society, after superannuation, the time is extended for 11 months. That is under challenge, my lord. Because rules does not contemplate the extension, my lord, after the age of superannuation.
You know, the society has filed this writ petition. The society has filed this writ petition.
Yes, my lord. So primary society has filed.
Writ of quo warranto to prevent and prohibit respondent number 3 from holding and continuing in the post of managing director of the second respondent, the regional oil seeds growers cooperative societies.
My lord, I am appearing for respondent.
Respondent number?
My lord, respondent number 2 and 3, my lord. My lord, kindly fix a date, my lord, in the next week, my lord. I will argue the matter. This is with regard to serial number 32, my lord. I'm sorry.
How 32?
Kindly next date, next week, I'll have an update.
At the request of learned counsel for response number 2 and 3, release this matter on 31st of March.
Please.
33.
Madam, 33.
In B group, madam.
Yes.
Number 33, madam. This is a urgent matter where the petitioner who is working as a principal and professor in the respondent institution has been illegally retired even attaining the age of 50 years, my lord, whereas the age of retirement as per the ACC scheme is 64 years, which I have produced the scheme. And recently a judgment also I have produced along with the IML for disposal.
Vice Principal, HOD, Department of Pharmacology.
Yes, ma'am. The impugned order is annexure G, my lord, page number 32. He straight away relieved, my lord, though he has got the age of retirement, and the order says that you are retired on attaining age of superannuation. This is
a private unaided institution, huh?
Yes, yes. That very question, my lord, that very question was considered in the judgment. One of the questions raised was because it is not a case where an inquiry is conducted or anything. I am illegally thought to be retired without any holding.
Inquiry conduct
Enquiry and illegal retirement and
illegal retirement.
My lord, any question AICT person can be retired before his attaining. Kindly see page number the IFR disposal, the judgment of this honorable court.
But if it is the same question, then you'll have to go before the division bench. I have sent those matters to the division bench. This cannot be because there are conflicting decisions. There are conflicting decisions, sir.
But there is no it may be posted, my lord, but urgency is there, my lord, because as on today it is not.
I can't decide this, sir. Having sent those matters to the division bench, how can I decide this matter now?
My lord, the interim order may be granted and then
I can't pass any interim orders. You want, I'll immediately send it along with those matters.
Yes, my lord, please.
You go and make your submission before the division bench.
Yes, yes. Please, my lord. Urgent.
Under similar circumstances, this court in WP number so and so. Noticed that there are two conflicting decisions of coordinate benches of this court, and therefore directed that the matters be placed before Honorable the Chief Justice to refer the matter to larger benches. Stop. Consequently, registry is directed to tag on these matters with the WP number so and so.
At the earliest, because my lord, he is without the salary.
Yes, yes.
At the earliest, at least, your life.
You please go and find out. Yes.
At the earliest,
Allunu urgency is there. Our urgency is there. You please go and see. You please go and find out. Yes.
But I'm for the petitioner, my lord.
Yes.
And matter relates to selection and appointment to the post of chairperson of the National Commission for Homeopathy, my lord. As per the notification annexure B, my lord, page 37.
Yeah, what is it? It's coming for what now? Today?
And it is
interrogated application.
IFR posting, my lord, the matter.
You have filed objections. You have served a copy.
Yes, my lord. Yes, sir.
No, let us see. List this matter for final hearing. Issue rule. List this matter for final hearing.
Lord, matter relates to selection and appointment to the post of chairman, my lord. Let there not be a rule be issued, my lord. A date be fixed, my lord. It's a short point whether the third respondent is qualified or not for the post, my lord.
It will come up in B group. B group only, non-court only, it will come later than final hearing matters.
But then date may be fixed, my lord.
ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇರೋದು.
Please.
I am giving a date.
Please.
List this matter on 5th of April for final hearing.
35 is stay.
Last occasion, my lords, I directed my learned friend to verify regarding the status with the election of second respondent. Matter pertaining to my lord selection to the post of my lord assistant engineer. Requisite qualification to hold the post.
Who is on the other side? Sanjeev. PL Sanjeev. Early hearing. ಏನ್ ಮಾಡೋದಪ್ಪ 2021 ಮ್ಯಾಟರ್ early hearing.
But the private respondent is not coming up, my lord. May I request my lords to kindly see the order sheet dated 3/3/2022.
Did you find out what has happened?
He has not come. He has not come.
Then he said he will take instructions regarding your appointment.
My appointment.
ಹೇಳಿದ್ರಲ್ಲ ಏನಾಯ್ತು?
ಹೇಳಿದ್ರು. ಅದಾದ್ಮೇಲೆ ಏನಾಗಿಲ್ಲ.
ಯಾಕೆ Mr. Sanjeev is not being coming? I don't know whether he's not well or what.
My lords have noted it on 3/3. Thereafter, my lord, on 21/3 also, my lord, lords directed to comply with the earlier order. But short point is when my lord, one selection process is commenced, you cannot change the rule of the game. Now, my lord, the selection process is provisional list is published. I have been selected in the main list. Thereafter, there is a change in the recruitment rules. It is a draft rule is published. Changing the qualification. In the changed qualification, the private respondent possesses the requisite qualification. Can it be applied to the provision to the list which is already provisional list is published? That is a short point. Therefore, my lords, while issuing notice, this one court, my lord, in the peculiar facts of this case, state the selection. But I have applied under broad scheduled caste category. But he also applied under the very same category. The first notification says qualification is, my lord, engineering plus 6 months diploma. But we participated in the selection process. Provisional list is published. My name finds place in the provisional list. Thereafter, draft rule, cadre and recruitment rule is published, reducing it to 3 months. 6 months diploma is reduced to 3 months. In the main list, his name finds place. My name is pushed down to additional list. Private respondent is working as AE in ISRO.
ಅದಕ್ಕೆ ಬಂದಿಲ್ಲ ಅವರು.
Could be disposed of. That is the short ground and not the.
ಆಯ್ತು ಬರ್ಕೊಳ್ಳಿ. Having noticed the submission of the learned counsel for the respondent board that although appointment order was issued to the second respondent, he has not responded and did not join duty. So, therefore, the learned counsel for the respondent board sought for a short accommodation to secure instructions and make his submissions regarding the appointment of the petitioner. Stop. Nevertheless, on the last occasion, there was no representation for the first respondent board. Full stop. Today too, there is no representation. Full stop. Release this matter on 28th of March 2022. Full stop. If there is no representation for the first respondent board on the next date of hearing, this court will proceed to pass necessary orders.
Sticker GM.
ಅವರ ಅವ್ರ ಬೆಳಿಗ್ಗೆ ಅವರ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೇಳಿದ್ರು. At the request of learned counsel for petitioner, release this matter on 31st of March.
37. You agree?
What is the matter about?
Petitioner has been deprived of their seniority basis in the selection.
The second respondent, Air India.
Earlier it was Air India, now the application has to be heard, my lord. Application. Now it is being taken over. 100% shares have been transferred to Tata. Therefore, the petition itself would not maintain it because
it is no more a government agency. It is a private corporation.
It is being taken over by.
Correct. So therefore, how do you maintain a writ petition in the matter of seniority in respect of the employees of a private company? Allah, anyway, you are saying that you want to file application to either implead the new entity by deleting the old ones, or you want to retain them. Whatever you want to do, you are seeking for some time. But you will have to answer the preliminary objection raised from the other side. Huh?
We will submit this later. Please pass on my while.
No, sir. Monday. I will list it on Monday in orders list. Only to hear about the maintainability of the writ petition. Huh? Workers.
Application is not maintainable because the present application they are seeking to increase the shareholders. The company nature of structure has not been changed. So Arabia as an entity is an entity as of now. Only the shareholding pattern has been changed from 100% government entity has been transferred to special vehicle of that essence. So that application is also not maintainable.
A preliminary objection is raised at the hands of the respondent. In fact, all of you are raising that objection. I will take it that all of you are raising objection at the hands of the respondent, stating that since the second respondent, Air India Limited, has now been taken over by a new entity and is now known as
only the shareholding has been changed. Arabia as an entity stands as it is, and there is no change in the management or structure of Arabia. Only shareholding has been
Preliminary objection is raised at the hands of the respondent, stating that since second respondent Air India Limited has now been taken over
by the Tata Group. Talis.
Phase 2, TALSD. By submission, small submission. Definitely that regarding maintainability.
That is why we are giving you time. What have you filed? Yes, yes. TAL Messrs. TALACE, Thales Private Limited. And the Government of India is investing 100% of the share holding to Messrs. Thales Private Limited. This writ petition cannot be maintained against a private entity, since the private entity would not answer to the definition of state as provided under Article 12 of the Constitution of India. Full stop. As per us, release this matter on 28th of March 2022 in orders list. Yes.
In this case, what is working as the data entry operator from class. It was appointed by the third respondent Panchayat Lord in the year 2014. Annexed A and B Lord are the proceedings Lord drawn by the third respondent Panchayat regarding appointment of the petitioner. The petitioner Lord, after working for 3 years, Lord had went on Lord maternity leave for about 6 months. By the time she reported for duty Lord after the maternity period, the fourth respondent Lord has been illegally appointed by the third respondent Panchayat. So the petitioner Lord thereafter Lord enrouted through a private contractor. He was being directed to come through a private contractor, which the petitioner had protested. And thereafter Lord, the second and the first respondents have investigated into the matter regarding appointment of the fourth respondent. And the first respondent, while annexed JM Lord, has directed to remove the fourth respondent from the post and to approve the selection of the petitioner. But in spite of that, Lord, the third respondent Panchayat Lord is not taking any action in the case. Yes, Lord, the petitioner had made repeated representations for which no action has been taken by the respondent.
Issue notice to all the respondents. Chaitanya. Yes.
Age may kindly be given because Lord, for the last 3 years, she has not been paid. She is working.
Very nice.
Any short statement.
ಸಾಕು ಆಯ್ತು. ಅದು ಯಾವ್ದು ಇದರದ ದಟ್ ಗೋಡೌನ್
Yes, appearing for respondent. I already filed. I already filed my statement of
no, Lord, I have filed the affidavit. But prima facie, Lord, it appears that Lord, there was no Lord, I have no document to show that Lord, I have handed over the charge. But I have filed the affidavit to the effect that from my Lord, the particular date, Lord, my incumbent has taken the charge. He received the stock. Therefore, Lord, I have got the explanation.
No, if he has received stock, then more than what you handed over should have been there. On the contrary, about 700 odd tons are missing.
He is missing. But then it is attributable to him.
May make one submission.
Kindly see my affidavit, Lord, para 7.
May make one submission. My Lord, yes. The joint inspection report has been conducted in presence of the petitioner, and he has signed the joint inspection report, and he has admitted the shortage of my Lord, the food grains to the extent of 700 and odd quintals. He has admitted in the inspection. He has given a statement.
Objections file madidira?
Yes, my Lord, I filed. Yes, my Lord, have stated. I filed all the documents also.
I am not in the mischief area. But the alleged incident has taken place at Lord Bannur. I have been transferred to Shikaripura. Even if I am allowed to work at Shikaripura, but departmental inquiry will not prejudice. That is why, my lord, I have relied upon one decision, my lord, 2013.
You were read out that day.
If suspension is a mechanism to keep me out of mischief area. The very purpose of keeping me under suspension is not.
I released this matter on 28th of March 2022 in the orders list.
Please, my lord, much okay. Interim order, my lord.
Interim order to be extended, if please mention.
Good afternoon, sir. Good afternoon.
Serial number 50, sir. 50. Mention ಮಾಡಿದ್ದೀಗ ನಾನು. Entry ಮಾಡಿ extend ಆಗ್ಬಿಟ್ಟು ಸರ್. Next week.
ಬೇರೆ ಯಾರ್ದಿದೆ ಸರ್?
44 sir.
Court officer serial number 45.
44 please.
Interim order ಇದೆಯಾ?
ಇಲ್ಲ.
Interim order ಇದೆಯಾ?
44 interim order ಇಲ್ಲ.
45 ಬರುತ್ತೆ ಮೇಡಮ್. Interim order ಇದ್ರೆ ಹೇಳಿ.
ಇಲ್ಲ.
ಓಕೆ.
44 ಯಾವಾಗ ಸರ್?
ಸರ್ ಬರುತ್ತೆ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಬರುತ್ತೆ. ಬೇರೆ ಯಾರ್ದು ಇದೆಯಾ?
47.
Interim order ಇದೆಯಾ?
ಇಲ್ಲ. Respondent ಇರೋದು ಅದು
ಬರುತ್ತೆ.